recognize him. I know only his name. So I'll wait. And in case the local lawyer comes, I'll contact with him and then mention it again before your lordship rises today. Grateful, your lordships.
Wait, please, madam. Prayer for listing of an admission matter, madam, as per lordship's convenience. Okay.
Next week sometime. Next Wednesday.
Deeply obliged.
My lord, item 66 of supplementary list, my lord. My lord, I will be allowed to withdraw, my lord, because the grievance of the petitioners already read this. my lord.
Item 66 on the submissions made by Mr. Hussain, counsel for the petitioner,
Grievance of the petitioner addressed, my lord.
who submits on instructions that the grievance of the petitioner has been redressed. The writ petition stands dismissed on withdrawal.
Obliged,
In
my lord.
orders, if the need stands.
But
The
if I'm
pending
appearing-
IL were also dismissed.
I mean, for BTC lordship. For BTC lordship.
Mr.
MK Das lordship. MK Das.
M.K. Das appears for the PTC. Are you also in item 63?
No lordship. Obliged lordship.
May I please, I'm mentioning for listing of contempt matter for orders on 3rd of November.
3rd November may not be
The
possible.
thing is that they filed an SLP that was dismissed and our service is not confirmed till today. Despite there been order in 2024, my lord.
7th?
7
November.
obliged.
Yes.
Well, I wish to mention item number 49 and 50.
49, 50.
49, admission matter. I have some problem. May I pray that the matter may be adjourned for 1 week.
You're for the
I am petitioner.
petition.
Item number 50.
49, 50 on the request made by the counsel for the petitioner stands deferred. Be listed after 1 week.
Lordship, I beg to mention for admission of a matter which was listed in the month August, Lordship. Next week, if possible. Lordship.
12th November.
12th of November.
Lordship, I beg to mention item number 68 and 69 of supplementary list, Lordship.
Yes.
Consent has been taken in H. Gupta has been appearing in this case, Lordship, and he is out of station. But this may be adjourned today, Lordship.
68, 69.
68.
Have you informed the counsel for the petition?
Yes, Lordship, consent has been taken.
Stands deferred on the request made on behalf of Mr. H. Gupta, learned CGC. Matter stands adjourned to be listed after 2 weeks. Submitted. Consent of the counsel for petitioner has been obtained.
Obliged.
Please, your lordship. Lordship, I beg to mention a matter for listing for admission, lordship, as per your lordship's convenience.
7th November.
Lordship, much obliged.
Lordship, I beg your lordship permission for listing of a matter. He has been deprived of getting the pensionary benefits and regular pension. So may come up on any date, lordship.
12th November.
Lordship.
Well, item number 49 and 50, your lordship has already passed over. May I pray that the date may be fixed? Maybe on 20th November.
On?
Item number 49 and 50,
Oh.
lordship has already passed over. May I pray that the date may be fixed, my lord.
Date.
20th November, my lord.
14 November.
40. Highly honored.
May I please, Lord. My lord, this is a pension matter, my lord. On 2nd September, my lord, the Learned Council with the respondents for 2 weeks time. However, till date not listed, my lord. On Monday, my lord.
7th September.
May I please, your lordship. I beg to mention for listing of admission matter, maybe on Monday, my lord.
7th.
May I
Ob-
please, I will mention for listing, my lord, admission matter, my lord.
Hmm.
Admission matter listing for,
Listing.
yes, my lord, on 7.
12th.
Obliged, my lord.
May I please, lordship. And motion matter, my lord, filed on yesterday, my lord. Matter pertains to my lord selection of constables
It will come. Why are you making a mention? Subject to clearance of defects, it will come.
tomorrow, my lord. Tomorrow.
Not tomorrow. As and when it comes, it comes. What is the urgency? It must be tomorrow.
Interest of the petition has been rejected on the ground of height, my lord, shortage in height, my lord. Your lordship already disposed of some matter.
All right. Tomorrow. Yes.
Yes, ma'am.
May I please, your lordship, I beg to mention, last posting was 05/9/2025. So, but.
You wanted better to be listed for what? For admission?
Orders, lordship.
For orders?
Yes.
All right, 12th November.
May I please, your lordship, but I beg to mention for listing of a matter as unlisted matter today, my lord.
Why?
Because, my lord, the petitioner applied for the post of Safai Karmachari, my lord, the result has been declared, my lord. But although the petitioner applied, but in the result shows that he has not applied at all. And the date of
Let it come
appointment is
tomorrow. Let it come tomorrow.
Fine, fine.
Tomorrow.
my lord.
Yes.
My lord, I'm praying for
Subject
listing
to
of matter,
clearance
my
of
lord.
defects.
Fine.
I'm
Yes.
praying for listing of matter, my lord, pertaining to non-payment of salaries for 40 months. The matter had come up, my lord, prior to the vacations, my lord, the judicial order. Which state-
12th November. 12th
My
November.
lord, if your lordship may please to fix a date prior to that, my lord, because the man has not been paid his salary and the matter was listed to be listed directly upon.
All right, 7th.
I'm grateful, man.
The recommendation this series item 13 to 48. I am in my lord, 28 to 48, my lord. My lord, review has been dismissed. My lord. I want to bring on record, my lord, that order, my lord. The date may be
You have to bring on.
review, my lord, by which my lord, OM dated 2020 OM was said
You
to
want
be.
to, you want to give the order of the review. Place the order
In
of the review.
record, my lord, bring in record, my lord, by filing.
Review.
additional appeal. Yes, that order, my lord.
It has been dismissed, my lord. Otherwise,
so
we have a
then-
copy, I can provide it
That
directly.
copy you can place it before the court.
And what the report was.
Because, my lord, the SLRC in this.
You let the matter be called up.
Yes,
Wait.
Please. You're praying for listing on contempt matter, though court is directed to list this matter after 2 weeks, lordship. But 2 months already over. Next week, any date, lordship. Some urgency is there.
7th.
Second.
7th.
May please your lordship, I beg to mention for listing. Lordship, there are 3 contempt matters.
Hmm?
May please your lordship, I beg to mention for listing. Lordship, there are 3 contempt matters.
Have it on, say, 12th or 14th? 14 November. 14 November. Yes.
May it please your lordship. Lordship, I beg to mention item number 64 of the daily list, your lordship.
64.
Lordship. Lordship is seeking some accommodation in the matter as the engaged counsel is
Huh?
having some personal difficulty.
You are making a mention on whose behalf?
On behalf of Mr. K. Chaudhary.
K. Chaudhary.
Lordship, we've informed the respondents.
Item 64 on the request made on behalf of Mr. K. Chaudhary stands deferred to be listed after 1 week.
Lordship, it
Submitted
will be
that
2 weeks. your lordship.
the consent of the council for the respondents have been, council for respondents have also been involved. List up 2 weeks now. Adjourned to be listed after 2 weeks.
Lordship,
Yes.
there is also an interim order operating in this one.
Why are you making your submissions in piecemeal? What is wrong with the interim order?
Lordship, it needs to be extended.
Is it till today?
Yes, it's still the next returnable date. Lordship, it has been extended till the next returnable date.
Interim orders, if any, stands. Then we can't give it to you 2 weeks. You come back again on 12th. 12th November. Interim order, if any, shall continue till the next date fixed.
Blessed you.
Yes, please, your lordship. Lordship, here the petitioner was rejected by the appellate board, finding his height to be 160.
Some instructions were sought for.
Yes, lordship, we have received instruction, as per our instruction, that the provision 2.5 is medical guideline that is applicable on at the time of DME, lordship.
At the time of?
DME, detailed medical examination. And the PST is conducted as per the guideline of notification, advertisement, lordship. And as per our advertisement, the height should be 170.
Bring it on record.
Yes, lordship.
Let it be on record.
In that case, lordship, a post may be kept vacant for the petitioner, lordship.
First, let it be on record.
Lordship, otherwise, if I may place, lordship, if suppose a person is rejected by the PST board, how can he go before the medical board to get his? height
We'll examine that matter. Today, the instructions are that whether this fraction of a centimeter less than 0.5 is to be ignored. They say it cannot be ignored
Lordship,
on the
otherwise,
basis of some instructions.
otherwise, lordship, the Honorable Calcutta High Court as well as Division Bench of the Bombay High Court, they have passed orders
What
to,
orders?
to relax the to give relaxation.
They pass orders ex parte.
Lordship,
Where there's orders ex parte,
not expert.
then we are giving them time to bring it on record. We'll hear you.
That case, short date may be given, lordship.
Sort it. Yes,
2 weeks time, lordship. Notice not issued, lordship.
need not be issued. First, you bring it
Yeah.
on record. Let us see if we
Yes.
can close it in the
2
motion
weeks,
state.
lordship.
In by that time, lordship, the medical examination will start.
We'll
lordship.
see about that. What do you want? Without qualifying, you want a post to be kept vacant. The question is whether this has to be ignored or not. Once we decide to ignore it, then we'll see what orders can be passed to consider your case. I heard Council for Parties, MS.S. Borwal and stuff. TGC submits that she has received instructions which reflect that the fraction of a centimeter less than 0.5 cannot be ignored. She therefore submits that she'd like to bring these instructions on record by way of an affidavit. Meanwhile, the counsel for the petitioner on the other end submits that there are judgments by other high courts which have interfered with such actions undertaken by the respondents. And in that view of the matter, he submits that post of constable. This is constable.
Constable GD Lordship.
ED. He may be kept vacant for the petitioner in the event he succeeds in the writ petition. Considering the submissions made, we permit the respondent authority to file their affidavit as expeditiously as possible within a period of 2 weeks from today. Prayer for the petitioner is permitted to renew his prayer for interim on the next returnable date. List again on on 14th November.
Similar instruction is on supplementary list motion 50. Item number 65, let's see. Similar,
65.
yes, that's
Same issue.
Same issue.
All right.
Two petitions.
This 1 and 65 be listed together on 14th. Same order.
public.
For admission items to be.
May I please, Your Lordship? This matter is relating to engagement of caretaker in a Jal Jeevan House. Your Lordship. The petitioner has given a certain plot of land to the authority for construction of Jal Jeevan House. And in that place, Lordship, it was issued that the petitioner will be given the job of a caretaker. Subsequently, Lordship, they were intended to select the respondent numbers, Lordship, 7. And to that effect, Lordship, detailed representation was filed. And before that, Your Lordship may kindly come to page 27.
We had disposed of one matter recently.
Yes, Your Lordship, there's one matter disposed of.
We had directed the
Also Secretary of the PNRD, Your Lordship.
PU,
Secretary, Madam.
Secretary of the Zilla,
the case before the water user committee.
Zilla Porikhod.
Gaon Panchayat.
Gaon
Gaon Panchayat. To place as per the notification, my lord, guideline, my lord, the appointing authority is the water user
Do
committee.
you have the number of that?
My lord, I'll, after some time,
All right.
we can place it.
You have a look at the order. We have directed them to, because there is a committee constituted to decide who will be the caretaker. So let that committee take a decision in the matter in respect of you vis-a-vis the respondent.
Let that copy.
Yes. Or Lordship may fix the matter on a very short date, my lord, I'll submit to him tomorrow. That will be better, my lord.
Monday?
We place it order, Lordship.
Monday. Right. This matter be listed on Monday as it is submitted by the respondent council that a issue, a similar issue in a writ petition has been disposed of by this court and you'd like to refer to the said order passed by this court. in connection with this matter. List again on Monday.
Objection.
Item 3. Dear Lordship, the petitioner has been placed below her junior 10-year junior Lordship for in the impugned gradation list at page 34 for promotion from the post of junior assistant to senior assistant. Lordship will kindly have a look at page 34. It is the forwarding letter. Next page is the gradation list. My name is at serial number 2, petitioner Nanda Das. Column number 7, Lordship will see initial date of joining Purabi Das 30/12/2004 and mine is 7/5/1994. Now this has been prepared. Heading Lordship will show statement showing provisional gradation list of junior assistant as per seniority, both the establishment of district fishery and deputy director in connection with promotion of junior assistant to senior assistant. Now, this is the issue. Here, Lordship, an interim order is operating that impugned gradation list may not be given effect to in respect of both these persons. Purabi Das service completed, she has not participated. And Lordship, today is perhaps the 12th occasion they have not filed a reply. And
Who is the respondent?
Fishery, Lordship.
Fishery department.
P. Sharma used to appear. And Lordship, there are many orders of this honorable court wherein it was directed that it will be taken up for admission hearing, last chance. Several directions are there. Even on the last occasion.
No counter affidavit.
No, even on the last occasion, it was directed a last chance for reply. There are many such orders, Lordship. Even on 22/8/25, it was directed that failing to file reply, appropriate orders will be passed. Otherwise, it is a very small.
What is your grievance here?
Grievance, Lordship, basically this impugned gradation list at page 34. By this gradation list, I was given 3 days time to submit my objection. That is at page 34. Page 34, I am reading, Lordship.
Yes.
In enclosing herewith the provisional gradation list of junior assistants so prepared by the district level selection committee for promotion from junior assistant to senior assistant under the establishment of the district fishery development officer Kachar. In this connection, you are hereby informed to furnish your views, objection, if any, on the said list to the undersigned within 3 days from the date of issue of this letter. Otherwise, the said gradation list will be treated as final list. So this is the gradation list. I am Nanda Das at serial number 2. My date of initial joining is 10 years earlier prior to that of Purabi Das, that is S4 number 6. Then I have given my objection, page 36, within 3 days. List is 211, I gave my objection 4/11/23. 4/11/23. They set over the matter, so I approached this honorable court. This is the second round of litigation. In the first round of litigation, operative portion, page 39. 39. May I read from the order, Lordship? Page 39. Its operative starts from be that as it may.
39 is 39. You is in the earlier round of litigation.
Earlier round of litigation.
Why? What was the final? What was the order passed?
Court directed to consider my representation and finalize the issue and prepare the final gradation list. And till then, this gradation list may not be given effect to.
Then what order was passed?
They have passed an order, page 42.
Yes.
May I read this order, Lordship? Upon perusal of the order dated 18/12/23, passed in so-and-so by the Honorable Guwahati High Court in compliance of order in respect of objection submitted by Nanda Das, Junior Assistant of this office of the District Fishery is disposed of on the following grounds. The Honorable Guwahati High Court passed judgment in writ appeal number 27/2010 in so-and-so by holding that gradation of ministerial staff of grade 3 at the district level should be treated as district level grade as per Handbook of General Circular 1968. Accordingly, the Director of Fishery issued order under memo number so-and-so dated 28/4/16 and accordingly committee finalized the gradation list by meeting dated 23/12/2021. As per the gradation list, the names of 4 employees were prepared, namely Mustaq Ahmed, Purabi Nath, Nanda Das, Arnab Dev were approved by the department, and Mustaq Ahmed was promoted in accordance with list approved by Director of Fisheries dated 24/1/2022. Out of the 4 incumbents, Purabi Nath submitted her no objection being serial number 2 in the said list, and writ petitioner objector Nanda Das submitted her no objection against the said list in which she was shown to be in serial number 3. And Sri Arnab Dev also submitted his no objection certificate against the said list in which he was shown in serial number 4. Upon creation of new vacancy, the district level committee prepared gradation list by resolution dated 6/11/2023, following the earlier list dated 23/11/2001, which was finalized and approved by department. The committee is bound to follow the earlier list finalized and approved by the higher authority. The writ petitioner objector is also bound to follow the earlier no objection petition dated 23/12/2021. The objector writ petitioner joined on 1/1/2001 in the district on transfer from Dima Hasao following the continuation of service in the district of Kachar. The claim of the objector writ petitioner is on state-wise cadre but not district-wise cadre. The list was prepared on the basis of district-wise cadre. Moreover, the objector petitioner has already relinquished her right by her no objection letter dated 23/12/2021, and as such, her case for promotion shall be considered next to Purabi Nath. The promotion of Purabi Nath is warranted as per approval of list dated 17/12/2021 by higher authority on the consent of both the party, Purabi and Nanda Das. Hence, the question of making any correction of gradation list prepared earlier does not arise, and any alteration would be in violation of earlier approval by higher authority. In respect of gradation list and in view of the above gradation, the objection petition of the objector is with no merit. Now, Lordship, they have taken few grounds. First of all, they say that my seniority is on state list, and this is seniority is on state list. This is district list. So this Lordship will see page 35. This is a amalgamated list of both the establishment of district fishery development officer and deputy director fisheries, and this is and here Lordship, it is clearly evident that Purabi Nath is much junior to me, Lordship. 10 years junior to me. 10 years junior to me. And the reference they have given of the writ appeal 27/2010, that also I have enclosed at page 43. There is nothing adverse against me or the issue involved in this particular case in that particular writ appeal, Lordship. In that particular writ appeal. Then they have said they had already finalized the seniority list on 2 dates they have given. Second paragraph they have given 23/12/21. And at para 5 of the impugn order, they have given.
There is a writ appellate order.
Yes, that I have enclosed 43. It says that for the ministerial staff, seniority has to be maintained district wise. So that does not affect me, Lordship. I was originally appointed in the office of DFDO Kachar. I was transferred to NC Hills on administrative ground, and again transferred back to DFDO Kachar on administrative ground on 19/11/2020. So never ever I was transferred on own request or mutual ground. I was transferred on public interest and transferred back to again Kachar on public interest. So there is no reason that I should lose my seniority. And a junior who joined much later in 2004, she cannot become my senior under any circumstance. And there is no question of giving up my seniority. One cannot waive up his fundamental right, Lordship. That is the settled position of law. Then again, Lordship will see in the impugn order, they have mentioned that 4th paragraph from below, they have mentioned that the objector writ petitioner has already relinquished her right by her no objection letter dated 23/12/2021. I had never given any no objection, Lordship. Had I given some no objection, there was no requirement for speaking any objection.
No, what is this list? They say it is on a state-wise cadre.
Lordship will see the heading of this gradation list.
No. You come to the speaking order.
Speaking order, yes. This case, Lordship, relates to Agriculture Department, this writ appeal, and their Lordship, 2 gradation lists are
Come to
maintained.
the speaking order.
Yes,
Page
bro.
number 42.
Yes. Honorable Guwahati High Court passed judgment in Writ Appeal number 27/2010 by holding that gradation list of
Below that.
as per gradation list.
Committee is bound to follow the earlier list finalized.
Yes.
So upon creation of new vacancy, district level committee prepared a gradation list by some resolution.
Then there is a statement contradictory to that, Lordship. In the fifth para.
Had you given some no objection?
I have never given any objection, no objection. At the time of promotion of one senior, Mr. Mustaq Ahmed, third paragraph, Lordship will see, they had sought for our no objection for promotion of Mustaq Ahmed. Although it was not necessary for promoting any person, no objection of any other person is not necessary. So at that time we had given no objection. But for seniority, Lordship, there was no question of any no objection. Otherwise, Lordship, they would not have sought for any objection by this letter at page 34. They have sought for objection within 3 days. If any person has any objection, page 34, Lordship will see.
So what is the meaning of this? Out of the 4 incumbents, so that you had submitted no objection. Against what list?
My lord, in this case, my lord, P. Sharma is not well, my lord. P. Sharma is not well, my lord. He is hospitalized, my lord.
Somebody else has to
My
represent.
lord, may I pray, my lord, this matter may be taken up after 1 week, my lord. I will reconstruct a brief, my lord.
Is there only one standing counsel for the filing?
He is handling the matter, my lord.
It can't be. If he is not well, then somebody else.
My lord, I will be there, my lord. I will be there in the next date, my lord.
That information you should have given us instead of, the allowing the petitioner to proceed in the hearing matter.
Actually, my lord, I was on legs in another court matter. Sorry, my lord.
You come prepared, we'll take it up on Tuesday next.
My lord.
Tuesday.
My lord.
Heard so-and-so, learned counsel, and it's Sutia, learned counsel. You are the state counsel.
My lord.
Submits that the standing counsel engaged in the matter by the department. Mr. P. Sharma is indisposed and therefore she has been entrusted with the brief. She, however, submits that.
Instead of my lord, Tuesday, can it be on Thursday, my
No,
lord?
Tuesday.
Published.
The matter be listed again on Tuesday.
Interim order may be continued.
Whatever is there will continue.
Okay.
List on Tuesday, date to deliver.
Item 4. Last to given, my lord. The Finance Department time 6 time for filing affidavit plus 2 occasions, but they did not file an affidavit, my lord.
Yes.
Your Lordship, we had received our instruction, Your Lordship. However, the instructions are incomplete, Your Lordship. We have communicated to the department for fresh instruction, Your Lordship. Pray for a short date, Your Lordship.
What affidavit you need? This is a departmental inquiry.
My lord.
Punishment.
Imposing, my lord, the 2 increments without cumulative, my lord, effect upon the petitioner.
What is the ground for challenge here?
Challenging that, my lord, I am submitting, my lord, I wasn't promoted to another place of posting. And in the meantime, my minor daughter was hospitalized. And I pray for a modification.
What is the ground for challenging the proceedings?
Ground for, because of that, I am only by they doing the against me, by the similar same issue, my lord, they have others were considered for my lord, modification of the transfer order, my lord. They did not, my case is, my lord, taking a vindictive manner, but they others were same that, my lord, they are considered it.
Where is the inquiry report?
Yes, my lord, inquiry report, please kindly see.
Where is the order of the disciplinary authority?
Yes, my lord. This is the inquiry report, page In my lord, page 90 and 85, my lord.
This is the order of the disciplinary authority.
Miles.
Yes.
4/7/2024. And inquiry report, please may kindly see page 79, my lord, and Annexure 16, operative portion, my lord, page 80. May I read, my lord?
Page?
Page 80. Observation and findings. On perusal of record and statement and after examine all facts and information following the observation revealed, it has been observed that dealing with officer had prayed for alteration of his place of posting in the promotional order on medical ground of his family member members. Also, it has been observed that department has considered his fair petition and proceed the same. Subsequently, department issued so-and-so complied with the department 5 days time, but instead of obeying the order, the delinquent officer had resubmitted the fair petition for the modification of his transfer order. As the department received the number of petition, alteration, modification, transfer order, in order to maintain the administrative discipline, department completed initial departmental proceeding against the so-and-so. Delinquent officer could have opted availing leave so-and-so. In view of the above findings, the charge disobedience in subordinations are established whatever wherever circumstances dealing with officer non-compliant to government order. However, while deciding the punishment penalty as prescribed Rule 7 of Assam Disciplinary.
Where is the inquiry report?
The ground appeal on medical ground of the family members and checking alteration of his place of position may be considered sympathetically on humanitarian ground. This is the inquiry report, my lord.
This is the inquiry report.
My lord.
This is the findings in the inquiry. Where is the inquiry report? The
The-
inquiry report begins at?
This is the findings of the inquiry report, my lord.
No, but where is the report? You were not given a copy of the report.
No, well, this is only I am received that.
Huh?
This is only I am received.
Did you file an appeal?
Yes, sir. I also file appeal.
Where is that appeal?
Appeal, my lord, please may kindly see
Hmm.
page 90. Appeal preferred under Rule 16, and that was also rejected.
Were you served with a copy of the inquiry report or not?
I am not received, but this is the only
Did you
report.
take this ground before the appellate authority?
No, no, that is a report, my lord. Then treat it as a report, my lord. Inquiry officer, my lord, page 80 last, my lord. So it's a inquiry officer, secretary to government of the finance department. This is the inquiry report, my lord. And I also filed reply against the report, my lord, page 82. Annexure 18. I'm hearing necessary, my lord, that may be fixed, my lord, on Tuesday, my lord, or Thursday.
You are not ready today.
I some decision also for today. I am, because of that, I am waiting for the filing affidavit.
What affidavit? This is you are challenging the proceedings.
My lord.
This is available in the records. If there is anything, we'll call for the records. But
Then
first you have to satisfy.
Lord-
Why are you challenging this?
Lordship directed to file affidavit, so that's why, my lord, I am on Tuesday, my lord.
Heard counsel for parties, the matter stands deferred to be listed after 4 weeks. The respondents may file their affidavit in the meantime, if so advised.
My lord, fix a date now, other.
The matter is fixed today. You're not ready to do the matter.
I am ready, but I am clicking on that, my lord.
We are ready to hear the matter, but you're not ready to urge. If you're ready to urge, we'll hear it.
My lord. My lord, everything I know, my lord.
After 4 weeks.
My lord, that may be fixed, my lord.
No date fix. If you are ready, when you are ready, you make a mention, we'll fix a date. All right. Fixing a date means the matter comes up. Some preparation is there on this side also.
Today, last occasion, today is fixed for filing the affidavit.
Why is an affidavit necessary? You ask yourself and tell us. You are challenging the proceedings.
My lord.
Is there any dispute on facts?
My lord.
It's a good thing that they have not filed. You should have, we expected you to argue the matter.
And I'm,
Yes.
actually, I'm ready, but I think, I lord. Not my, that may be fixed otherwise.
Let the affidavit come. You receive, then you may like to file a reply. Again, why fix a date? So you make a mention after the returnable date. We'll take it up.
Items 5 to 8.
Yes.
Lordship may kindly have a look, the last order, 2/9/2025.
Confusion কি confusion আছে একটু? In the course of deliberation of confusion regarding one of the respondents. As a answer for the parties have submitted. File is clear.
What confusion arose?
Lordship, the confusion is, Lordship, the petitioner in WPC 5119. He is also a respondent in WPC number 8394 of 2019. That is item number 8. And my learned friend, Lordship Islam, he appears on behalf of my client in item number 5119 2019. So the honorable court has directed them, either he has to withdraw his wakaltnama in respect of Nurul Islam Ahmed, or Lordship, my learned friend Bhuya, A.R. Bhuya.
Yes, sir.
You will have to implement that particular name.
We have not understood what.
Lordship, there is an order.
Wait. In this writ petition, respondent 7, there is a private respondent.
Lordship.
Who represents him?
He is
You are representative. So this private respondent is also a writ petitioner in 8394.
No, Lordship. He is also a respondent.
There.
There.
Respondent.
There is a mistake committed by, AR writ petitioner. The selection candidate wrongly carried your lordship. There is a name is same.
Okay.
Nurul Islam Ahmed, Nurul Islam Sheikh.
Nurul Islam
There
Ahmed
was-
and Nurul Islam Sheikh.
Lordship, there was AR was directed to file a petition for correction of the name of the respondent. By the lordship.
No. What is the correct name of the respondent?
Nurul Islam Ahmed, yes.
Ahmed.
Nurul Islam Sheikh, it should be Nurul Islam Sheikh.
It is
But-
written here, Nurul Islam Sheikh.
No, in item number, Lordship, item number 8394 2019. Lordship, WBC.
8394.
Okay. But I have given a copy, Lordship. Lordship may have a look at. I have the order.
You have that. Right. Yes. Here what happens?
Here, Lordship, the respondent number, Lordship may kindly see respondent number 15. Nurul Islam Ahmed, son of Abdul Aziz SK, village Bhimpara. And Lordship, my learned friend Islam, he has accepted notice on behalf of respondent number 15. And at the same time opposing him in WPC 5119 in the first writ petition.
Nurul Islam Sheikh. কি কৰিব লাগে সেইটো কোৱা? Problem কি কৰিব লাগে? চব কেনেকে কৰে? তুমি উত্তৰ কৰিবা এটা।
Fact is that Nurul Islam Sheikh is the selected candidate. I am representing selected candidate by the petitioner. If is inadvertently name had written as Nurul Islam Ahmed. That is a mistake by the.
Mistake in the petition, but how have you represented him? There, in the
I am
subsequent,
representing. I am not representing.
who are you representing?
I am representing all the selected candidates. I have not filed on behalf of Nurul Islam Ahmed. I am filed on behalf of Nurul Islam Sheikh. All
But
the
he's not a
selected
party.
That's what I was saying.
Is he a party here?
There is a
Yes,
mistake.
Lordship. 25/11/2019 order, Lordship may kindly see to issue notice returnable on 18/12/2019.
2511 passed in which matter?
In item number 8394 of 2019.
এইটো একদম 5 নম্বৰ আইটেম। তুমি 7 নম্বৰ আইটেম হয় এটি।
25/11/2019. order.
7 নম্বৰ এটি হৈছে না তুমি?
Yes.
সেইটো উদ্যোগ
2511.
2019. In WBC 8394 of 19 laws.
কৰিলি। কৰিব লাগে নালাগে?
Well, I it is selected candidate. No.
This 8394 is filed by whom?
ARV. He has challenged the entire list. He took any. He took control of the
And this is filed by, who is the petitioner here?
Petitioner is Lordship Abdul Latif SK and 64 others.
Now you are saying that in respondent number 15, name is wrongly written.
Wrongly. He is not the selected candidate. In item number 5, he is the selected candidate.
So
Therefore, the ARV was asked the last occasion to clarify that for correct his name. So he has accepted notice on behalf of respondent number 15. During Lordship, he is the petitioner in WBC 5119. Address is same.
maybe, but
Others name is
the challenge, what is the challenge in 8394?
He has challenged the entire select
Select list.
That-
So this respondent 15's name should be reflected in the select list.
Not-
Is it there?
Because initially, Lordship, my name was there in the first item. The issue is, Lordship, initially, Lordship, I was selected. Then by corrigendum, Lordship, they have sent the list. Thereafter, Lordship, his name came. Nurul Islam Sheikh.
So which select list is challenged in 8394?
Final select. Final select list.
There is only one select list.
One select list. Two select lists, Lordship, same day. Okay, the substantive payment is there.
Yes, tell us.
Now it is upon them, Lordship. So, in terms of this order, Lordship, they have to correct this.
Let us hear your challenge first. What is your challenge? You are challenging his selection.
I am challenging his selection of the respondent number 7, Nurul Islam Sheikh. Because initially it was my appointment, and by corrigendum, Lordship, they have changed my name, and without there being any minutes, any office note. That is why, Lordship, this honorable court has repeatedly asked them to produce the original records.
Who is to produce the records?
My lord, a record is, my lord, before the special court. And now I have received the status of the special court. The special court, my lord, search it has been filed, and last occasion, my lord, on 30th November 2024.
Have they filed affidavits?
We have filed affidavit, my lord.
Long way.
The record is there, my lord. That's why original record, my lord, it will be difficult to produce it, my lord. Earlier, one, my lord, photocopy, that record was produced. That was
Why is it difficult to produce?
No, my lord, we will have to, my lord, write to the officer to
Who's
have.
stopping you? When the records are required by the court, why are you hesitating to write?
That is true, my lord.
to the
That is
concerned
true.
officer?
So earlier occasion, my lord, what happened, my lord, photocopy was sent. That photocopy was sent, my lord, this is Nurul Islam Sheikh and Nurul Islam Ahmed. And originally, Nurul Islam Ahmed was selected, shown selected. Thereafter, by corrigendum, the Sheikh has been, my lord, replaced. That is the case.
Lordship, the
That
original.
can only be found out from the records. What happened?
Original records, my lord, I will have to call.
Lordship, the original record was once produced by my learned senior friend. No,
photocopy.
Original also.
Once it was.
That was a
produced, and
photocopy,
once it was not produced, and we have received highest mark.
Hmm?
I have obtained highest mark. Once it was produced, the mark sheet of the selection interview, and in that interview report, I have obtained highest mark. That's why they have corrected. Mistake was corrected after half an hour later. That's why.
Mistake cannot be corrected like that. There should be a minus, there should be office note. Where is that? They have not been able to produce.
Last occasion, my lord,
This is for selection of what? Gampura?
Alternative remedy is there. In fact, appeal provision is there. And
Huh?
alternative remedy is there. Appeal provision is there. Where is the director?
So what will happen in the appeal?
They have not prepared. Directly they have come to High Court. But this, our High Court judgment also there. Appeal provision is there. Recently, this is also dismissed by this court. They can go for appeal. Alternative remedy is there, your lordship.
Better we call for the records.
Better call for appeal.
When can you produce the records?
3 weeks time, my lord.
3 weeks.
My lord,
Why?
Because it's a record in the special court at a copies stage, madam. Now is a copies stage. Copies are not ready. Copies is rated to keep copies ready by the next date. In the meantime, I think that has been served.
Last order says it might be in the custody. Why have you not informed the court as to what is the status of the record? Is it there or not?
I have to check it, my lord. I don't know, my lord. I have forgotten, my lord. Earlier occasion, I had seen, my lord, one photocopy, my lord. That was a photocopy sent by the police officer.
Where is that photocopy?
That was, my lord, I will have to check it, my lord, whether available on office or not, or it is return it. And I will check it, my lord, in 3 weeks, my lord. I would clear it.
3 weeks is a special court where?
Guwahati, my lord.
Then
2 weeks later, my lord.
next week.
Next week, my lord.
Next week. You at least apprise us what is the status? What steps you have taken to procure the copy?
But I will
Who
check
have
it.
you communicated with? What is the reply?
I will check it in office.
This writ petition is filed by the petitioner putting a challenge to the select list dated so and so, by which the concerned department has had concluded the selection process, reflecting the names of the selected candidates for the Gaon Pura for the concerned villages. Stop. The dispute. The grievance of the petitioner is that it is his claim that in the select list, his name was initially recorded as Nurul Islam Ahmed, son of Abdul Aziz Sheikh, resident of Fulchar, PS South Salmara district, South Salmara, Mankachar, Assam. Stop. Subsequently, he came to be informed. Subsequently, when the select list was published, he came to be informed that it is the respondent whose name is reflected in the select list in place of the writ petition. Name of the respondent is Nurul Islam Sheikh, son of late Gyan Bepari, resident of village Bhimpara, post office Hatsingimari, PS South Salmara, district South Salmara. Stop. The counsel for the petitioner submits that this interpolation of the select list to include the private respondent, number 7, was done by the respondents, which is contrary to law, and therefore the challenge has been made to the state select list. The respondents have contested by filing their affidavits. So the issue raised before the court on earlier occasions, this court was of the view that the dispute can be resolved by calling for the original records of the department pertaining to the selection process undertaken. Stop. Consequential orders were passed by the court, the respondents. The respondents on the other end submit that because of a criminal case initiated through the CM's Special Vigilance Cell, being CM Special Vigilance Case number 5 of 2021. The original records have been submitted before the special court Kamrup, Guwahati, stop. Mr. T.C. Sutia, additional senior government advocate, submits that he will have to obtain clear instructions as to the status of the records. And also to communicate with the department to procure the same for placing it before the court. So the earlier orders passed by the court reflects that several opportunities were granted to the respondents to produce the same records. However, the records are still not before the court. The Government Council also does not have instructions as to the status of the records and as to when the same can be produced. In view of the submission that the records are before the special court, we permit Mr. Sutia a week's time to complete his instructions and apprise the court as to the status of the records. Let this matter be listed again on 3rd of November. But by which date Mr. Sutia will apprise the court as to when you are not necessary. We are dealing with the Government Council calling for the records. You request your colleague to be present if required.
Also, may kindly extend the interim order in item number 5 and 7.
Allow us to complete the order first. The Government Council will apprise the court as to what steps have been taken to procure the records of selection as called for. List on 3rd, interim orders wherever granted will continue till the next date fixed. Copy of this order be marked to the office of the Senior Government Advocate, Assam, for onward communication.
Item 9.
Yeah, please, you look.
May I please? The petitioners, Your Lordship, 12 in numbers, Your Lordship. They were initially appointed by Your Lordship, NHM, Your Lordship, under National Health Mission, Your Lordship, as a computer assistant, Your Lordship. That's a percentage selection process, Your Lordship. Your Lordship will get the page 22, Your Lordship may kindly come. These are the appointment letters, Your Lordship, issued to them. Selection as computer assistant, Sirang district. You are selected for engagement of contractual basis under NRHM for the post of computer assistant, Sirang district. In similar manner, Your Lordship, others were also appointed, Your Lordship. And then, Your Lordship, along with them, Your Lordship, they were appointed as in district offices of NRHM, Your Lordship. At a relevant point of time, it was named as NRHM, and some were appointed, Your Lordship, in the head office of the NHM, Your Lordship.
As computer assistant.
Computer assistant. Now, Your Lordship, so far as the present petitioners are concerned, they are all belong to the group, Your Lordship, who were appointed in district offices, Your Lordship.
In the?
District offices, Your Lordship.
District?
Offices, Your Lordship, of NHM.
Of NHM?
NHM. At a relevant point of time, it was NRHM, Your Lordship, subsequently it became NHM. Now, if Your Lordship comes to page 33, Your Lordship. This is an order, Your Lordship, issued by the Mission Director, National Health Mission, Your Lordship. They have, Your Lordship, by this order, Your Lordship will find, Your Lordship, that before that, Your Lordship, page 32, Your Lordship, may kindly come. Those computer assistants who were working in the state mission office NRHM are redesignated as administrative assistant, Your Lordship. So far as petitioners are concerned, Your Lordship, they were not designated. They remained as, Your Lordship, computer assistant, Your Lordship. Now, Your Lordship, with effect from 31st March 2017, Your Lordship, the post of computer assistants were, Your Lordship, discontinued, Your Lordship. That Your Lordship will get at page 33, Your Lordship.
Page 30.
Okay.
Page?
33.
Hmm.
In pursuance of Government of India order number so and so dated 22nd July 2016 and approval recorded in the NHM Assam dated so and so 12 August 2016, the following post under National Health Mission Assam are hereby discontinued with effect from 10th of January 2017. Now, Your Lordship, in second, it is computer assistant. Now, Your Lordship, the respective program officer at state level and the joint director of health services come member secretary of the respective district health society at district level and sub-district level may engage persons for this task on the task rate basis to the extent possible or on outsourcing basis. No new recruitment are to be taken up for this position. Subject to satisfactory performance, the incumbents presently engaged in those posts may be engaged in their respective position on lump sum basis, and the remuneration may be paid from the approved lump sum budget per ROP 2016-17 up to so and so. Now, Your Lordship, we were discontinued as such, but allowed to continue on lump sum basis, Your Lordship. Then, Your Lordships, we have been continuing, Your Lordship, and certain, Your Lordship, payments were also made to us. Enhancements, some sorts of enhancements were also given. Now, Your Lordship, there is a demand from us, Your Lordship, that we should be paid the salary equal to those, Your Lordship, in the state office which were reassigned as administrative assistant, Your Lordship. Since we were appointed similarly, Your Lordship, we have still been continuing, Your Lordship. Then Your Lordship may kindly come to page 48. This is a letter by the Your Lordship, Director of Health Services, Family Welfare, Your Lordship, to the Mission Director, NHM Assam. Subject upgradation of salary structure of existing contractual computer assistant under UIP and fixation of tenure up to 6 years for contractual employees more than 10 years in service. Petition submitted by 16 contractual computer assistants, stroke immunization program assistant under UIP so and so. Gautam Assam letter number so and so and so and so. With reference to the above, I would like to state that out of 27 district level computer assistants, the existing 16 number of CAs are recruited in 2006 onwards by NHM Assam under contractual basis and placed under disposal of additional CM and Chief Medical and Health Officer FW and DIO concerned district. They have almost 12 years of experience in immunization division. As per ROP 2019-20 base salary proposed by NHM for the post of district level computer assistants, initial recruitment 2006 is under rupees 15,282 plus 5% per month under FMR code under 16.4.2.1.9. However, as per ROP 2019 and 20, the base salary of CA under PCPNDT is rupees 21,957 per month under FMR code so and so. Although both the cadre are same, CA UAP and CA PCNDP are base salary should be treated as same under contractual appointment. Now it is proposed for refixation of base salary of contractual CA UIP along with experience bonus of 15%, more than 10 years and yearly increment of 5%. Now Your Lordship will find that CA UIP in rupees 20, this is the base salary and total salary per month will be this, Your Lordship. Then Your Lordship, in page 49, Your Lordship, the name of the petitioners were mentioned, Your Lordship. And proposed salary is also shown, Your Lordship. Now further with reference to Gov letter number so and so dated Dispur 27th August 2020, it is proposed for fixation of tenure up to 6 years, benefit like ELCL, maternity leave, gratuity, etc. for the above UIP employee who has served for more than 10 years. Thus, I would like to request you to look into the matter as they are being working in the same field for the last 10 to 12 years and does have gained vast experience in the field of immunization, but are being deprived of their basic salary. This is for your kind information. Now, Your Lordship, even after this, Your Lordship, there have not having been any steps taken by the authorities, Your Lordship. We came before this honorable court, Your Lordship. And
This communication is by Director Health Service.
Director, Your Lordship, that's page 43, Director, Health Services, Family Welfare, Your Lordship. This is because, Your Lordship, we work under them, Your Lordship, although under NHM, Your Lordship, payment is made, Your Lordship, remuneration is paid. We have been placed
What
under
is
the
PAUIP?
UIP, Your Lordship, Universal Immunization Program, Your Lordship.
And this PCPN?
PCPL, Your Lordship, this is also a scheme, Your Lordship.
You follow
UIP.
Huh?
We are in UIP.
UIP. Then
It is, Your Lordship, preconception and prenatal diagnostic technique scheme, Your Lordship. This PCPNDT, Your Lordship. Now, Your Lordship, at that stage, we came before this honorable court, Your Lordship. And initially, they filed an affidavit, Your Lordship. And in the affidavit, Your Lordship will kindly come to running page 53, Your Lordship. They have not para 10, Your Lordship.
yes.
That as regards is made in para 13 of the deponent begs to state that the matter of remuneration equal to permanent employees outside the purview of respondent number 1 and 2 as mission director NHM. The petitioner is engaged on lump sum budget and therefore there is no provision for equivalent remuneration as that of the contractual employees. Then para 11 also they said that it was revised as per minimum wages act along with annual increment. Then, Your Lordship, this honorable court, Your Lordship, passed an order, Your Lordship. Your Lordship will get that order at page. Your Lordship will get that order. Your Lordship is dated 13/2/2025. After.
In this writ petition.
In this writ petition.
Yes.
Para 6 onwards, Your Lordship. First 5 paragraphs, Your Lordship. Case was detailed. The executive director NHM has filed an affidavit. However, according to this court, such affidavit nowhere addresses the issue raised, except statement at paragraph 10 that the petitioners are being paid as per minimum wages act. In the opposite backdrop, the executive director NHM is to file a press affidavit, taking their stance clear whether the petitioners and their counterparts were posted at state office or appointed under the same selection process, and what is the response of the executive director NHM as regard the communication dated 28/10/2012 issued by the Director of Health Services, Assam. The said executive director shall also clarify in its affidavit on what basis a stand was taken that the petitioners are being paid as per minimum wages act and they were engaged on lump sum budget. Now, Your Lordship, pursuant to that, Your Lordship, they filed a affidavit, Your Lordship. Now, Your Lordship will get it at page 62 of the running page 62, Your Lordship. In this affidavit, Your Lordship, 5 paragraphs are there, Your Lordship. The questions posed by the honorable court, probably in Lordship, in my humble understanding, has not been answered, Your Lordship. Your Lordship will kindly come to.
If this affidavit is filed on?
This was, Your Lordship, dated 28/3/2025.
28/3.
Pursuant to direction, Your Lordship, issued by.
Additional affidavit.
Additional affidavit.
All right.
Para 2, Your Lordship, deponent begs to state that originally the petitioners and their counterpart state headquarters were appointed under the same selection process computer assistant. The computer assistant engages state headquarters, assigns some administrative responsibility, including day-to-day letter order, typing, report compliance and analysis, processing files related to different programs. However, the petitioner is assigned for immunization related activities and its reporting purpose. Rest of different job duties assigned to computers and engage state headquarters. Their nomenclature are changed to administrative assistance by the order that is so and so. There is no intention to discriminate the petitioners by changing the designation. That the deponent begs to state that as per direction of the government of India, by letter number so and so, new position of data entry operation supports the category of staff being engaged with lump sum basis minimum wage. However, the position earlier engaged is contractual position, the so and so, including petitioner still continuing with earlier remuneration with subsequent annual hike in remuneration as per provision of letter number so and so. Moreover, they are being provided all other benefits including leave, medical reimbursement of 5 lakhs, etc. as that of compensation under NHM Assam. That the dependent beg to state that regarding pay fixation, which has already been answered, the above para that petitioners are being provided similar annual increment in remuneration and other Assam according to their performance appraisal grades and subsequent order of for none of the petitioners reduced. Moreover, any grievance if received, it is examined immediately and redressed accordingly. Service tenure of petition is also being considered as that of other contractual side. Ultimately, Your Lordship, what happened to the letter, Your Lordship, at page 48? What action they have taken, that has not been answered by the authority, Your Lordship. And in fact, Your Lordship, my case is that, Your Lordship, after serving under NHM for these long years, Your Lordship, maybe, Your Lordship, is a contractual service, Your Lordship, which would but it is perennial in nature, Your Lordship. It has obtained permanent character of a permanence nature, Your Lordship. But, Your Lordship, we are not coming here for, Your Lordship, regularization of service. But the fact remains that when we have been serving like all other regular employees.
Computer assistants,
Lordship.
you are deprived of the basic salary,
Lordship.
base salary.
Lordship. That is, Your Lordship, like
Which the,
others are getting. Your
which others?
Lordship, the page 48, first of all, Your Lordship, has clearly mentioned who are the others, Your Lordship. Those computer assistants working under, Your Lordship, PCP and DT scheme, Your Lordship. And secondly, Your Lordship, if Your Lordship comes to page 41, Your Lordship, we have prepared a chart, Your Lordship. Your Lordship will find in that page 41. This will show, Your Lordship, that the persons, Your Lordship, who were initial pay were similar under NHM, Your Lordship. Your Lordship will find us at serial number 4.
Yeah, health department, what is your stand in pursuant to the communication?
Yes, madam. So far as this communication, there is annexure F. Lordship will find page 43 of the writ petition. There we have replied. This particular annexure is connected to para 7.
40?
43.
Please.
Yes. No, 43 of the writ petition, madam. This is the communication of the, first of all, Director of Health Services Family Welfare. He is not the appointing authority.
No, 48 is the communication.
48. But there is a representation.
No, 48, annexure F. Letter dated 28th of October. I think the page numbers could be different.
Yes, might seems to be different. No, it is annexure F.
There is a suggestion by the Director Health Service.
Yes, Family Welfare.
That the base salary should be same.
Yes, ma'am.
So,
and this particular annexure is part of para 9, madam. We have replied to that in the affidavit that we have filed. So they will see page 52. running page 52. Para 7. As regards to statement in para 9 and 10 of the writ petition, referent makes to state that the enhancement of the remuneration of the lump sum positions is considered based on the revision of minimum wages, etc. Since these are not ROP approved positions, therefore, their enhancement depends on the availability of budget in the ROP. My lord, here Lordship will see, my lord, that document. There's some error in the designation, but my lord, basically, Annex of B2 1. 32. Yes, 32. 26/4/2012. The petitioners herein, they were engaged sometimes in 2006 to 2009 as computer assistant. Now, my lord, on 26/4/2012, the post of computer assistant has been redesignated as administrative assistant.
Only for the,
Employees who are working in the headquarters in the NSM office.
but they are employees of the district level
Yes, ma'am.
and sub-district.
Now, while, my lord, this was done thereafter in 2016, my lord, page 33, Annexure C, the post of computer assistant has been abolished. However, a decision was taken that, my lord, they will be engaged, they will be allowed to continue on a lump sum basis. Last para, my lord, page 33. And accordingly, my lord, they are continuing as on date. Now, my lord, their grievance, my lord, Lordship will see the prayer for a moment, my lord. Prayer in the writ petition. Page, my lord, 18. Relevant will be page 19, my lord.
Yes.
So and so like nature should not be issued, directing the respondent authorities to give adequate and regular increment on salaries to the petitioner. Lordship will see, my lord, they are, my lord, praying for increment and also subsequently providing them with the benefit of nature of EL, CL, maternity leave,
That I
gratuity,
think is
etc.
already granted, is it?
That's why I'm saying, my
That
lord.
is that part.
This is their prayer, my lord. In the additional affidavit that was filed, my lord, pursuant to this honorable court's order. Even in, my lord, this first affidavit also.
That ELCL is already granted.
That is already granted, my lord, during the pendency of the writ petition as a full, my lord. Lordship will see, my
Your
lord.
regular increment,
And your
That is not his prayer, my lord. That is not their prayer. And, my lord, their discontinuation has not been put to challenge. It has been discontinued. Despite that, my lord, we have, my lord, they allowed them to continue. Now, if they don't want, that's a different issue.
no,
Yeah, that's what I'm saying, my lord.
that it's not that they don't want, they want something more.
Something more, my lord. But prayer, my lord, is only, my lord, increment. Increment has been allotted to them.
Prayer is to give regular increment.
That, my lord, we have stated in our affidavit, my lord. And, my lord, our leave.
Increment is not available to you.
Lordship?
How can regular increment be available?
No, your lordship, regular increment so far as other NHM employees are concerned, regular increments are given. Now the point is, your lordship, what?
No. Are you saying that outsourced employees like you,
Yes,
employed across NHM, are also getting regular increment?
Lordship will kindly see, we are not outsourced employees. That is not their case, your lordship. We are not outsourced, your lordship.
No, you are on contractual appointment.
We are contractual. Even the other employees of the NHM are also contractual, your lordship. They were not, your lordship, regular. None working under your lordship, National Health Mission, your lordship, are your lordship regular employees.
No, but where is the, show us some examples to that they are getting some increments.
Annual increment.
When they are performing the same nature of jobs and their status is as same as you are.
Lordship will kindly see, that is why, your lordship, I am relying on page 48, your lordship.
48 is one
It
letter. but
clearly says, your lordship.
48 is just one letter. From your side, you must bring these materials to show that there are other persons who are also employed and doing the same nature of job, but they are getting certain benefits which has not been given to
That is what, your lordship, page 48 reveals, your lordship. Your lordship, when their own document reveals that, your lordship, the similarly situated, your lordship, persons under different scheme, your lordship, were paid, your lordship. And your lordship will kindly see, your lordship. Your lordship has
Does
already.
it give you a right? This page 48, does it give you a right to come before the court?
No, that your lordship gives an.
You have to crystallize your right.
That is
to pray and demand that these same facilities are not being given to you.
Lordship will kindly see that the basic, your lordship, this letter, your lordship, clearly, your lordship, reasons, your lordship, why what we should be given and why we should be given, your lordship. That is there very clear. They have not answered to this, your lordship. That is the point, your lordship. And
No, the letter only says it is proposed for refixation.
yes, your lordship. Why refixation is done, your lordship? That is, your lordship will get.
Whether the proposal was implemented or not.
That is not implemented, your lordship. That is why this honorable court asked them, your lordship, what they have done with this, your lordship. And that has not been answered by them, your lordship. That is one. And your lordship knows very well, your lordship, recent judgments, your lordship, although those relating to your lordship regularization, your lordship, honorable apex court, your lordship, it has very clearly shows, your lordship. Very clear terms says that, your lordship, the extracting of services, your lordship, in this.
Why don't we accept that this is substantially complied with because EL, CL, maternity, gratuity, everything is being released to you?
But your lordship, the rest, your lordship, so far as the increment and other parts are
The
concerned.
increment you have to show us, you are before the court. You have to show us that similar nature of work is being undertaken by similarly situated persons. They are getting it. You are being deprived. Show us at least one example.
Lordship, that your lordship, we have already shows, your lordship, what has happened to those similarly appointed persons in the state offices, your lordship, who are, your lordship, is getting.
There is a different, they have created a difference between those working in the head office and the district office. You are saying that even in the district, there are people who are getting it.
No, I have not said that, your lordship. That I have not said. What I have said, your lordship, I have your lordship will kindly come to page 41.
All right, you consider this, you pass an effective order. We are closing it.
Before that, may I, my lord, one para, my lord, page 65. Regarding increment part, you have replied to that. Page 65, para 4. Is the additional affidavit, para 4.
65.
That the deponent basis state that regarding pay fixation, it has already been answered in the above para that the petitioners are being provided similar annual increment, my lord, lordship will see. It is there, my lord, in the affidavit. They are getting it.
Page number?
Page number 65, para 4.
Para 4.
That the petitioners are being provided similar annual increment in the remuneration as that of the other contractual staff under NSM Assam according to their performance appraisal. So they are getting, my only thing, my lord, what is left out?
Wait, you are referring to the additional affidavit.
Yes, my lord, that 23/8/2025, 28/3/2025 affidavit. Running pace, my lord, starts at 62. So relevant will be 65.
Your lordship will kindly see, your lordship, that.
No, let me complete, my lord. My lord, last line says, for none of the petitioners, so moreover, any grievance related to remuneration if received, it is examined immediately and since accordingly, service of the so being also considered as that of the students. So, my lord, so far as this particular petition is concerned, their main prayer was that there should be, my lord, they should get the annual increment, earned leave, maternity leave, all has been provided, my lord. It is there in the affidavit during the pendency of the writ petition. What I have been told by the authorities that, my lord, by pursuant to this, my lord, representation at page 48. 25, 10, 21. Page 55. Page 55. This is the last representation made by the petitioner before approaching this honorable court. There also, my lord, para 6, my lord, of the representation, lordship will see. Here, grievance starts at para 6. That, sir, the annual increment at the rate of 5% were discontinued for computer assistant. That we have provided since 2016. That is, my lord, when they were post-abolished. And loyalty bonus. This part, my lord, as per information provided by the NSM authorities, this part has not been given. So if they want not, let the authorities decide on this part, my lord. Otherwise, they are getting all, except the lump sum part. And it is not their priority, my lord. They should get the same, my lord, remuneration as that of a, my lord, those working as junior assistant in the headquarter office, who are converted to, my lord.
What do you say to the reply?
Nothing is there, my lord.
We will kindly see, your lordship. Ultimately, your lordship, what they have done, your lordship, since your lordship, we are under lump sum budget, their own affidavit says, your lordship, that since we are under a lump sum budget, your lordship, we are not paid at the enhancement at the rate of the, like the other employees, your lordship. Now, your
That is not
lordship,
there,
will
my lord.
kindly, your lordship,
Para 4 of the
lordship,
additional affidavit
Lordship.
says that you have been granted annual increment.
lordship. Lordship, they said, your lordship, but your lordship, that is not, your lordship, we have replied to that, your lordship will kindly see. Apart from that, your lordship will kindly see, your lordship, at the end of the day, your lordship, the,
Have you replied to this?
yes, your lordship, we have, I mean, reply this one. Para 4, your lordship.
Oh, it's not there.
That is, yeah, it is there, page 69, your lordship. It starts from page 59.
Page 69 is your reply to the affidavit in opposition.
Lordship, that is your lordship.
This
is your lordship.
This page para 4 is the additional affidavit.
Lordship, this is your lordship, slightly your lordship, that to this your lordship we have replied. Your lordship will kindly come to page 72, page 72, your lordship.
Para?
Page 72, para 9, your lordship. That as regard the advertisement made in para 4 and 5 of the affidavit, the deponent states that deponent as the computer assistants under the immunization program have been unfairly denied their annual salary increment and as per order dated so and so. The said category was eligible for increments, however, deponent and petitioner were arbitrarily excluded from the list. It is stated by the deponent that continuation of order dated 30/3/2025 was also issued, yet the deponent and petitioner remain omitted from the list of employees granted increments. The read petitioners on 15/4/2015 jointly submitted a representation to Mission Director NSM Assam seeking a grant of annual income. However, no action was taken by the authority concerned, and as a result, the read petitioners are deprived of increments from financial year 267. It is further stated by the deponent from financial 17/18 onwards, the read petitioner granted annual increments as lump sum staff, but not at per NHM.
NHM staff, what is NHM staff? You are
Yes.
not a member of, you are not a regular NHM staff.
Lordship.
Then what is NHM
That is
staff?
your lordship, that is what
If you
our,
want to bring in parity, then you have to give examples that we are doing similar nature of work. The others are doing similar nature of work, they are getting more pay.
now your lordship, what is the basis on which your lordship they are paid? Only basis of lump.
Whatever
That is
basis-
what our case is, your
You
lordship.
can't,
That your
you
lordship
can-
only.
you cannot urge similar ground on the ground that somebody else is getting better pay, unless you draw analogy.
No, your lordship will kindly see, it is not about, we are, what we are.
Your basic prayer was increment and CL maternity.
Lordship, even your
So
lordship, that is
increment has been granted.
that is your lordship, even the base salary, your lordship.
No.
Base salary is also your lordship, they have not.
I think your
lordship.
You have been given the benefits, whatever you.
And your
asked for.
lordship will kindly see, your lordship, that is what your lordship, I am trying to impress upon your lordship, that they have been extracting our services, your lordship.
Oh, you look into the basic prayers, what you made.
Lordship.
Your basic prayers are grant of annual increment, CL, maternity leave.
Lordship.
So CL, EL, maternity, gratuity, everything has been granted. Now annual increment has also been granted.
Lordship. That is what your lordship, I am in reply that we are not, your lordship, in spite of the fact that we have been recruited under NHM.
No, it is not possible for the court to decide on what basis are you making those claims.
And
without any other
no,
logic.
that is why your lordship, what my prayer is, your lordship, as it has fallen from your lordship's mouth, your lordship, that is one of the authority, your lordship, this is the highest authority, director, your lordship, directorate. They have written, your lordship. Let them consider that.
Respondents have stated they have complied with it.
No, your lordship, that they have not complied with. They have not stated this.
You have not.
They have not stated that they have complied with this, your lordship. Therefore, your lordship, let them take a view or call on this. Our representations are pending. That has not been disposed of, your lordship. And your lordship will kindly see that there is a letter by the director. Let them consider it within a period of specific period of time, your lordship. and taking it pass a
There has to be pleadings to that effect.
speaking
This-
order,
this-
your lordship.
This affidavit was filed when? This affidavit was filed in that additional affidavit,
They have filed it after 13/9, your
March
lordship.
2023.
Lords, no, not March 23, your lordship. Your lordship will
Sorry.
kindly see their affidavit as
April 25.
lordship, 20.
April 25.
And that's why we have replied to that, your lordship.
You have not replied. Your reply affidavit is prior to that.
No, your lordship
Of
will
course.
kindly, your lordship will kindly see, your
Your
lordship.
reply affidavit was filed on
It cannot be, your lordship. I have stated, your lordship may kindly come to.
22nd of March 23.
Your lordship will kindly come to para 3.
Of which affidavit?
Last affidavit, your lordship, that is at page 70, 69,
No, no,
running
your
page.
Affidavit filed by whom?
Filed by your lordship, affidavit in reply filed by the petitioners, your lordship.
Petitioners. Filed on which date?
It was filed on, your lordship will get it at your lordship. 28th day of May 2025. It was at running page is page 69.
Yes.
There, your lordship, we have replied. We have just now read, your lordship, para 9. And that is as per the letter that so and so MD and says the employee is not provided for in. The whole problem is that, your lordship, since we are under lump sum basis, your lordship, we don't fall under ROP, your lordship, and therefore, your lordship, we are excluded, your lordship. That is our case. And your lordship, after expecting our services for all these years, if you don't include us, your lordship, that's the problem, your lordship. And that is what, your lordship, has been deprecated by the Honorable Apex Court, your lordship, in Jago and other cases, your lordship. Very clearly said, your lordship. Just one judgment I am relying on, your lordship.
Yes.
Lordship.
They maintain that their annual increments are not granted.
No, Lordship, what they have submitted, Lordship will see, my lord, that statement.
What I-
Para, my lord, page
Look,
72, yes.
My prayer will be, your lordship, even otherwise also, your lordship cannot direct them to, your lordship, consider it, your lordship. But your lordship will ultimately let them pass a speaking order on this, your lordship.
Yeah, but Lordship will see page 72, that last line, which has been pointed out my land plan.
No, we could have done everything, provided you could have shown us that the nature of work is one and the same. The post profile may be same. What work are you rendering? What work are the others rendering? Some analogy has to be there made in the pleadings. Some analogy.
No, your lordship will kindly see. I am, in fact, your lordship, we have not structured this petition.
In fact, the judgment which you are relying on is on the same premise.
No, your lordship, what I have, your lordship, what my whole case is based on the letter, your lordship, issued by the director, your lordship. Our case, your lordship. They have, your lordship, given a justification for, your lordship, refixing the base salary, your lordship. Now, your lordship, that they have not done, and they have explained why they could not done it. They said that you are in lump sum budget, your lordship, therefore we cannot bring into, your lordship, them into the, your lordship.
That is the reason why some analogy is necessary to show that you are performing the same work, irrespective of not being, irrespective of being on a contractual basis. You are doing the same work.
Lordship.
Yet, certain other benefits are granted to them which has not been given to you.
Lordship.
There is no ever.
That is what, your lordship, in
You are
para.
relying only on one letter of the department.
That's your
And
lordship.
they have filed their affidavit. You have objected to them. It's a question of, uh, they say that you've been granted a annual increment.
Lordship.
You say you've not been granted.
Then your lordship may, if your lordship permits me, your lordship, 2 weeks time, your lordship, I will show some, your lordship, bring in some material, your lordship, so that these benefits are not given to us, your lordship. It is
Not after
it-
hearing the matter.
Lordship, that I leave it to your lordship, your lordship. I will not, your lordship, press that, your lordship, but your lordship.
All right, we will pass some order.
Lords.
Heard this post.
Deeply obliged, all right.
Almost time being. Then do it at 2 at least, so that I know. That it won't be possible this way. Because he won't be able to finish also. Ah.
Please. One minute.
See, another matter fix is already 5 past 12. And then, for time being, you never know when it will come. So practically, it's very difficult. It's uncertainty is always there.
Yes.
There is an element of uncertainty.
There is?
Mr. There is an element of uncertainty, my lord, because Mr. Chaudhary is on the other side, Mr. K.N. Chaudhary. I'm for the respondent. But then he is in the midst of so many partners, busy lawyer. So.
Unlike you.
Well, unlike me, of course, that's it. But you know, now he says for the time being, but then another case he is having. So I just don't know. Then I'm in a catch-22 situation. I don't know what to do. I'm not free. Could it be any other date at least? Is it possible for him so that he's sure?
This is a partner matter.
My lord, actually what happened was before Justice Jamir, full-fledged hearing was done by both sides. Written arguments were also given. It was CAV for nearly 4 to 5 months. And thereafter, my lord knows what happened.
You know better than us.
My lord, all of us see everything.
What were you doing for 4 years? After the matter was heard?
After the matter,
You said it is CAV for 4 years.
4-5 months.
4-5 months.
Anyway,
What is the issue here?
Issue, my lord, actually, the case of the petitioner is he was denied promotion in the year 2022 from manager civil to senior manager civil. In 2023, he got the promotion, of course. So, but now the question is, if he succeeds in his 2022 case, he gets it from retrospective effect. That will be the entire.
How many matters are there? Only one.
One, my lord, but it's fairly, contest is always there. Because they have assailed the recommendation of Department of Promotion Committee. Promotion. Because it is 2022 he was denied by the Departmental Promotion Committee. Interview he could not clear. He could not get the qualifying marks in the interview. So this is what they have assailed. In 2023, my lord, he got the promotion. But if he succeeds in 2022, he gets it from retrospective.
Notional.
That is it. Otherwise, basically, he's already manager. Senior manager, could it be any other date at least? I am free. Otherwise, I'm stuck up.
Lordship, however, I have been instructed for time being, your lordship, but if my senior insists, then we may fix it for another date, your lordship, if your lordship.
It also next, Arunachal also. Say, for example, 27th, Monday?
Seniors. Doing Arunachal on that.
Arunachal. Thereafter, I will be in Arunachal. Okay. So could it be on then November, close to November, 10th November.
6th of November.
Oh, yes, yes.
Or 11th.
No, let it be 6th. 6th November. 6th better. I will also be here.
All right, 6th. 6th November is agreed to by council for the parties. Based on so and so date.
That's okay.
My lord will possibly read the arguments are there, I hope, in the file.
You will apprise us, you will refresh our memories, correct?
Because this time they may be wiser, so new grounds may be urged.
We
Anyway.
don't know. We'll see.
But my lord,
let me say, even 4-5 years is not an improbability. There are cases. It happened.
If you want to be heard on an elaborate manner, it's quite possible. But if you leave it to us, we can assure you that it is not going to be that long.
Not in the case of your lordship. I'm referring to something else.
No. Whatever you're referring includes everyone, including us.
No, my lord. I said,
So therefore, there has to be a mechanism to hear and dispose of matters.
my lord, but when the written
effectively.
arguments are given, one
It's
would
not about-
expect.
It's not about written arguments. Why do you want to give written arguments in every matter? You have your written pleadings here.
My lord, this came, this
we are-
came from the honorable court.
Judges are not supposed to, say too many things, but
Certainly.
in matters of, there are matters where the written arguments go well beyond the pleadings.
But when it comes from the honorable court, that better you give the written argument and it is duly given, and thereafter, my lord, if the judgment is not pronounced.
So let us not dwell on that. Let us
That's it.
try to finish off the matter.
Oh, let's hope on 6th November, Mr. Chaudhary would be in a situation to argue this case completely. Good.
Item number 11, my lord, as per the last order, some instructions were sought, my lord. Praying for 2 weeks' time, my lord. I have
That instructions because.
Mr. N. Deka, counsel for
APTCL, my lord.
APTCL, renews his prayer for further time to complete his instructions. Your Mr.
A. Chakraborty.
A. Chakraborty, counsel for the petitioner, does not object to the prayer made. Please again after 2 weeks.
Yeah, in the case, my lord,
Yes.
state authorities need to have filed additional affidavit to bring some factual position, my lord, as per the last order.
Lordship, we have filed an affidavit, my lord, the GAD. The spot number 2 as well as per the last order, GAD as well as the, my lord, the finance department was supposed to file, my lord. We are awaiting our instructions, my lord. As well as the, I think the, spot number 2,
Required from respondent number 2 also, Lord.
some time may be given, my lord. Otherwise, we have filed our affidavit, my lord. But, also the finance department has to file the affidavit.
Yes, what do you say?
My lord, they need to have clarified, my lord. Basically, is the case for, my lord, non-payment of my fixed wages, my lord.
Who is to file the affidavit?
By the, both, my lord, finance department.
Finance, my lord. as
Who's
well
for the finance?
as-
Why finance affidavit? He's employed under what, GAD?
My lord, and
My lord.
employed on the DC, my lord.
DC, Deputy
the
Commissioner.
appointing authority is the DC.
DC, who's for the DC?
Mr. Commissioner, affidavit filed by the respondent at 3
So what do you say regarding this non-payment of salary?
They simply said, my lord, matter was referred to the authority.
Which authority?
GAD, Lordship.
GAD. Why GAD is necessary? What has GAD got to do with it?
Page 40 of their affidavit can be seen, my lord. 40 and 41.
Non-availability of budget.
Yes, Lordship.
And also, my lord, paragraph 3 of our affidavit, we have stated there that there was an office memorandum, my lord, by which, my lord, they were of the finance department, my lord, where, my lord, prohibiting engagement of casual worker, casual employee, master role worker, work charge employee. So this person was a petitioner was a casual, I think, worker, my lord. So that
Not
was
casual, my lord. I was appointed, my lord, as a Malasi, my lord.
Finance department's,
But the
under the
period
concurrence
I
which they
worked,
have,
my lord.
they were asked to file the affidavit.
Finance never said, my lord, the period I worked, I should not be paid. That is not there.
What is the name of the petitioner?
Petitioner name is, my lord, Hemanta Chetia. He's a Malasi, my lord, have been worked under Deputy Commissioner.
Where is the appointment order?
The Lordship will see page 19. Fixed pay of 5,000 per month.
What is a Masalsi?
Masalsi, my lord, is a grade 4, my lord, kind of helper, my lord, in the domestic work. And Deputy Commissioner, my lord, time and again has written to the authority, my lord, that your lordship will be cleared from page 21, my lord.
Yes, Deputy Commissioner, what do you
Yes,
say?
we
You
have-
appointed somebody, we are not paying the salary, why?
We have write to the department, lordship.
Which department?
General Administrative Department, lordship. Our
By-
in page
which-
number,
Which
how-
communication?
page number 21 of writ petition, and also kindly come to the page 33 of our affidavit, lordship, filed by the respondent number 3. Page 7. Okay, paragraph 7, lordship. Page 33. And that with regard to
By
the,
the District Commissioner.
yes, lordship.
Okay, which paragraph?
Paragraph 7, lordship.
7.
Section 7 and 7. That with regard to the statement made in paragraph 5 of the writ petition, the deponent begs to state that the petitioner submitted 2 numbers of representation on 1/9/2020 and 16/12/2020 for release of these monthly wages. Accordingly, against the petitioner dated 1/9/2020, the additional district commissioner has informed that an amount of rupees 54,000 was paid to the applicant at the rate of 9,000 per month from April 2019 to September 2019. In response to this office call,
Yes, Mr. Gogoi, what happens after you are appointed post FRBM?
FRBM, my lord, before appointment, they will have to take the sanction. But the FRBM doesn't speak about, my lord, engaging someone with master worker or contractual with, or my lord. But in regular posting. Prior to advertisement, they will have to take a SIU.
No, this is a temporary appointment.
Temporary appointment.
What is the stand of the finance?
Finance, my lord, we are yet to file an affidavit, but here, my lord, first of all, they will have to show that, my lord, they have submitted some proposal to the finance, my lord, in this regard. Either from the deputy commissioner or from the GAD to the finance.
Now, how is the GAD involved here?
But so far as the other branch is concerned, my lord, falls under.
RM department.
Under the GAD. So any proposal from the deputy commissioner will directly go to the GAD, GAD will forward it to the finance.
Yes, any proposal sent?
yes. Yes, page number 22, 21, annexer 3 of writ petition, lordship, which
Page number
21, Annexure 3
of the
of writ petition.
writ petition.
Yes, Lordship.
Yes. Then what is the reply to this? Detail status.
Yes, Lordship.
Now, what has the GAD done after that?
Lordship, in EAD has, my lord, we have filed an affidavit, my lord. This matter, my lord, which is at page, my lord, 31, my lord.
What have you stated here?
Here, my lord, we have given that, Lordship sees paragraph 3 of our affidavit, my lord, filed by the, respondent number 2, my lord. Respondent number 1, sorry, my lord, respondent number 1. There, my lord, the answering deponent only state that though the Deputy Commissioner Sifsagar temporarily appointed the petitioner in the vacant post of Malashi, office of the Circuit House Sifsagar in fixed pay of rupees so and so. Finance Department issued several instructions, communications wide number so and so dated 12/3/93 and others as stated in the office memorandum number so and so dated 5th November 1999 prohibiting the engagement of so and so with effect from 1/4/93. Hence, the said appointment was not as per the guideline of the Finance Department. That with regard the statements made in
No, then what happened? Have you rejected the proposal or what?
my lord, that I have to get my instruction. But
You have filed an affidavit after that. Where is the
given,
scope for an instruction?
my lord, we have given them this thing that that this was not done as per the Finance Department's guideline. Therefore, on the last occasion, my lord, they were asked to file the affidavit also.
You have filed an affidavit and then you say that there are no instructions. What is the purpose of filing an affidavit?
My lord, we have written to the CS Sifsagar man that time, my lord, that the appointment was not as per the, my lord.
So what is to be done? Have you rejected the proposal or what?
Rejected most probably. I'll
This is, why did you file an affidavit with these half-baked instructions?
Also, my lord, if your lordship sees paragraph 5, we had asked for a detailed report, my lord.
That report has been sent.
Not been.
It has been sent. What detailed report you want? One man was appointed temporarily, he is working. What further report do you want?
The notification.
Huh?
Detailed proposals, my lord, in terms of the notification dated so and so, my lord. 3/10/19, of the Finance Department, that paragraph 5.
By which letter?
My lord. It is 21/2/21.
No, by which letter? 21-2. Where is that letter?
My lord, we have not annexed it here, my lord.
Where?
Not annexed, my lord.
Why?
22, that was not annexed. My lord, I'll have to get that instruction.
Yes, you get your instructions. What have you done? Have you submitted a proposal or not?
Yes, we have submitted,
Or
Lordship.
will direct the DC to pay the salary from his own pocket? Why? How can you appoint somebody without following the norms?
Page number 23, here also a communication to General Administrative
Oh, you
Department.
read why don't you read the affidavit, madam?
Page number
Kindly come to page number 33 of the affidavit. Paragraph 5, 34. There is a reference of some letter by the GAD requiring you to submit a detailed proposal. What have you done after that? Get your instructions here.
Yes, Lordship.
The grievance of the petitioner is non-release of his salary in the post of Masalsi in the circuit house located in Sibsagar. Petitioner was appointed. Petitioner was engaged temporarily by order dated 15 November 2014. Stop. According to the Department of, according to the GAD, the appointment has been made without following the guidelines or notifications issued by the Finance Department. So, in the affidavit filed by the GAD, it is mentioned, it is stated that the District Commissioner Sibsagar was requested to submit detailed proposals in terms of notification number so-and-so dated 3/10/2019 of the Finance Department. That page number 34. Stop. Where are the learned government council representing the District Commissioner on the other end does not have the instructions whether the detailed proposal came to be submitted subsequently. So, in order to proceed further in the matter, it is necessary that the respective council obtain their instructions and place it before the court regarding the proposals and the submitted or the steps taken towards the claim of salary or area salary of the writ petitioner. So list again after 2 weeks.
Well, the date may be fixed.
All right, sorry, yes.
A date may be fixed.
After 2 weeks to be listed on a date to be fixed by the registry. Yes.
Yes. In the case of the series, my lord, on the last occasion, my lord.
This is the series.
My lord.
Okay.
Series matter, my lord, about me, my lord, the status and fate of my medical examination by the medical college need to be placed before the court, my lord, so that I can have access and I can make my submission, my lord.
Lordship wanted to see, my lord, whether during the examination, how it has been conducted, how the percentage was determined.
No, first there was a mention about some review.
Yes.
Review matter. The review is against the order passed by coordinate bench saying that there is no infirmity in the subsequent medical test.
Yes, madam. But
That has been dismissed.
yes, madam. Yes. Madam, in review kindly see my lord paragraph 5, my lord. Order, my lord.
Para 5.
Para 5.
Yes.
On the strength of the materials available on record and upon hearing of the petition and the consent of the appearing of the petition, this court by an order dated 12/6/2024, my lord, relying upon the case of State of Uttar Pradesh and others versus Ravindra Kumar Sharma and others, held that the petitioner has not been able to make out the case to sustain the challenge to the legality of the OM dated so and accordingly the said OM was said to be valid. Then, my lord, the reason that the petitioner was not found to be suffering from benchmark disease on re-verification, accordingly, it was held that if the petitioner is selected and appointed in date for post on the strength of the medical certificate showing him to be suffering from benchmark disability, then the petitioner would be infringing the right of the candidate who, upon medical regulation, is found to be suffering from benchmark disability, which, in the opinion of the court, would be more unjust and incautious to persons actually found on merit regulation to be suffering from benchmark disability. My lord, the OM was said to be valid, my lord, relying on the judgment of the State of Uttar Pradesh, my lord. This judgment was passed, my lord, under the 1995 Act, my lord, where certificate can be reopened, my lord. My lord, and my lord, I had placed 2 judgments, my lord, before the honorable single judge, my lord. That is, my lord, para 10, my lord. Paragraph 10. This paragraph 10, my lord, I have cited two judgment. In this, in the recruitment of visually impaired man, my lord, the section 32 and 34, the reservation policy has been clarified by the honorable apex court by the subsequently, my lord, after passing of that judgment, my lord. If your lordship, I have the personal department saying the OM is now in force, 2020 force, but the SLRC, my lord, they are saying we are following the OM dated, my lord, 2019, my lord. Because in 2022 OM, my lord, they have given an additional right to the PWBD alone.
What are you submitting? You are submitting with regard to the order passed in review,
Yes, my lord.
which was dismissed.
Yes, yes, my lord.
Yes.
My lord, this was, my lord, OM was said to be valid on the basis of the Ravindra Kumar Sharma judgment, my lord. And I had also placed two judgment, Rekha Sharma and judgment. My lord, kindly see the Ravindra Kumar Sharma's judgment, my lord.
No, I'll not see. Why you are placing before me the review judgment.
Yes.
What is to be done here?
My lord,
You are agreed, go and appeal.
yes, I will find, my lord. I'm
So what
going
do you
to-
want from this court?
Yes.
Some direction that you will go and file an appeal.
No, this is required, my lord. In my lord, item, my lord, in one case, my lord, the personal department SLRC has filed affidavit in opposition. I have filed reply, and each in the reply, I have annexed the document.
This review is filed again in which writ petition?
My lord, there is the similar issue, the verification, whether they
Is it
can.
part of the series?
No, separate. Separate. But the issue is the same, my lord. He was already selected. The issue is whether they have power to reassess the percentage of disability.
That has been sustained by the court, saying that it has. It has the power.
Because the honorable coordinate bench held the verification word cannot be constricted money. It means, my lord, to reassess the, my lord, percentage of disability, my lord. But, my lord, there are, my lord, two OM in the issued by the government of Assam, my lord. One is 2019 and one is 2022. My lord, they are placing the 2020 OM, but the SLRC following the OM dated 2019, my lord. Because in 2020, 22, the OM, which was said to be valid, my lord, they have the additional, they have changed the reservation policy. They have changed it vertical, not horizontal, my lord. I have annexed a reply, my lord, in reply. They are referring to the OM of the 2019 SLRC. Even after validation of this 2022 OM. Accordingly, they are saying that we have the power because they have the.
It has been held by a coordinate bench that there is no infirmity in re-evaluation.
Yes.
You filed a review. Review was dismissed.
Yes.
Now,
But
why
they
are you
say,
urging this point again before this court?
yes. Therefore, I am, yes, madam. I am asking time balance, some.
So does it require that much of
Yes.
argument if you are praying for time?
Yes, madam.
We asked you, what do you want to do with this order?
Yes.
Yes, all right.
Madam.
Mr. Gogoi, what records were called for? Medical records?
I just wanted to see, my lord, how the candidates were examined by the medical board. What process they initiated, how the percentage were determined, my lord. And whether any medical examination step.
Let the council in your presence go through the
My
record. Then if you permit, they will
Yes,
take
sir.
some notes.
Yes, sir.
I may have access, my lord, because my lord, during pendants of the case also, medical college, very medical college examined me and found me, my lord.
We are permitting you to do that.
My lord.
Go through and then you address the court.
Yes, my lord. Today we may be permitted to see, my lord. Some other day, lordship fix, my lord.
Well.
I'll ask one of my junior brother to look into the record.
You ask why one, you ask 5 junior brothers to
No,
look
my
into
lord.
if you want.
Lordship may record
We are
my
not
name.
preventing
That
you
may
from
be
looking
problem.
into it.
If your lordship record my name, my lord,
That means I have to go myself practical.
Third council for parties, what are your item numbers?
Item number, my lord, 14, 15, 16, 17, 18, 27.
14, 15, 16, 17,
18 and 27.
27. Mr. J.I. Boruya, counsel for the petitioner submits that the records were directed to be produced in the records in respect of the medical examinations undertaken by the respondent have been directed to be produced. Para Mr. B. Gogoi, additional AG for the state of Assam submits that the records are available. Para Mr. Mia submits that that they may be permitted to peruse the records in the presence of the respondent counsel in court, and thereafter address the court on some other date. So since Mr. Gogoi has fairly not objected to the request made, we permit the petitioners to go through the medical records in the presence of the standing counsel and thereafter address the court on the next date fixed.
Yes. Lordship fix the rate matter, my case to be segregated matter,
Not segregated. Let it remain for the time being. Once you decide that the arguments are different, we'll segregate. Yes.
My only thing, is the record, Lordship, will say report, all.
Report. Medical report.
Medical documents, man.
Medical reports.
Report kya hoga?
Well, I'm appearing in item number 13, 19, 21, then 23, 24 and 25. In respect of those matters, I hope that my learned friend has the record.
My lord, honorable court only just wanted to see some reports. Accordingly, these we have, my lord. Whatever my lord J.I. Boruya has appeared, that we have. Not in all, in fact, 3 or 4 of my learned friend also we have. Otherwise, we'll have to bring every my lord candidate report that we can. But honorable court just wanted to see what process we have followed. So that whatever is there will place.
In our case, my lord, no affidavit has been filed by the health department. My lord.
Issue is same, my lord. Otherwise, if required, we'll file.
In our item 20, 22 and 26. Item 48, Lordship, we are challenging the notification of this government health department, Lordship. That has not been upheld in the previous. Challenge, that is the mother notification.
Which
Now the-
previous judgment?
The one referred to by my learner.
Not challenged, but there is a finding that it is permissible, relying on some judgment. Whether it is correct or wrong,
And that judgment was relied on in respect of the previous act, Lordship, 1990 or 95 act.
You're right.
This is
In
as per-
respect of which other items are available, you give a list, we'll direct that.
Yes, madam.
Item 13, 14, 15, 16.
You give the list, please.
Yes, sir.
His medical records are complete records.
Well, these are all reports, just lost in my parents one minute, like. Hey, Otherwise, technical issue, my lord, if required, you can call for some, my lord, assistance from the doctors also on the respective fields.
Partial doctor.
Just to explain the medical terms.
No, but it will require some, how will commoners understand that?
Yes, no, they can appear, man. One from each department, man. 3 departments. orthopedics
So
and
better you get a report from them. How these tests have been conducted, what are the parameters used?
but parameters, my lord, there is a guideline, my lord, how it is. to be-
So which
is
guideline?
Followed by the district authorities as well as the, my lord. That I have, my lord, I have flag marked it, my lord, but it will be difficult to understand on our part. In fact, yesterday they came to explain it to me. How it is assessed, my lord, it's technical issue, my lord. And that cannot be, my lord, issue, my lord, which is before the honorable court. Whether we can examine or not, my lord, that's the whole issue.
Did you? No, but without a finding, without a conclusion.
The conclusion, they finally percentage are there. They've assessed the percentage. Whether it is 40 or, my lord, below 40. If it is 40 or above, they are entitled. But here they have been found to be below 40. So they are holding a, my lord, certificate of 40 or above 40 from the district authorities. That's the whole issue.
No, we wanted these records to find out essentially that earlier the authorities were the district authorities, the health directors, the additional health directors or someone.
As per the act, my lord, yes.
Who had given the certificate.
Lordship.
Now let us say for a person who's visually impaired.
My lord.
Certificate is given that he has a benchmark of 40 or 50%.
Oh, yes,
disability.
40.
Is there a possibility that this benchmark can improve or the disability can go
Further
down?
deteriorate, yes, go down.
Is there a possibility?
Yes, my lord.
That is what-
Progressive, my lord, disabilities, my lord, they sometimes go down or.
That is a general thing. With regard to each of these candidates, there has to be somebody to say that the earlier finding was this.
Yes.
Now, for whatever reason, this has improved or it has gone down. Something has to
In
be
that
there.
case, my lord, the records, my lord, of the district will have to be examined by them, my lord. Then they can compare and, my lord, they
It
can
has
say.
to be.
Yes,
what to have been
otherwise
done.
it will be
What
difficult.
to have been done?
No, they were examined physically, my lord. Not on the basis of some certificate, my lord, which they are holding. They will examine afresh, not on the basis of that, my lord, or to verify whether that is correct or not.
All right, I'll think of something. Pursuant to the earlier orders passed directing the standing council heads to produce the medical reports. The standing council has placed the same, has produced the same before the court. Counsel for the petitioners are permitted to examine these reports in court in the presence of the standing councils, if they so desire. And the matters be posted on some other day, filed there to address the court. In respect of the writ petitions where affidavits have not yet been filed by the states.
Yes,
the endeavor may be made to file their affidavits if so advised. Yes, anything else?
Can you have a photocopy of the report, my lord, if
We don't know. We can't put it in an order.
One thing, my lord, my cases, my lord, are backlog case. Special recruitment. Not like.
We'll see that. We'll see that. Let it not get desegregated. Otherwise.
Fixing date, my lord.
Yes, can it be after 3 weeks in that case, whatever short affidavit is required? Otherwise it is covered, but we'll file it, my lord, since they are insisting, my lord, from the health department also. Any date, my lord, before, or by the end of November, my lord.
20 November? This matters be listed on 22 November.
But that list I have given, my lord, where we have got the report, item numbers I have provided.
Yes, yes,
In my case only.
yes.
Published, my lord.
Okay.
Item number 51.
Please, Your Lordship. In this matter, petitioner challenged the interim retirement notice, my lord. On earlier occasion, Your Lordship has passed an order on 27/5/25, my lord, after filing the appeals to produce the records, my lord. They have also asked to produce the records of that case, my lord.
Records available.
My lord, I am ready.
আছে চব আছে আপোনাৰ আগে কৰক যদি আপুনি আগে কৰিব বিচাৰে কৰক টাইম ল'ব লাগে লওক তাতে আপোনাৰ ইচ্ছা। Pleading is over, my lord. Pleading is complete. Or else my lord can fix it for hearing also, my lord.
Today I am ready to argue the case. Petitioner is suffering, my lord. For last 18 months, 19 months, he has not received his salary.
My lord, he is not in service. How he will receive salary, my lord? He has retired from service.
That notice has been under challenge.
In the service book, what is the basis for seeking correction?
My lord, regarding on the basis of the date of birth, my lord.
Date of birth, on what basis?
Annexer, as per service book record, my lord. I have annexed front page of my service book, my lord.
Page
at
number?
Page 27, Annexer D.
27. 31/3, 1970.
1970.
When were you appointed? What is your date of appointment?
The date of appointment, my lord.
Yes, my lord.
My lord, in page number 25. Page number 25, annexure C, serial number 21, Sukhdev Kaur, my lord, 11083.
Serial number?
21, my lord.
21.
My lord, if this.
Wait. What is this first date? What is the first date? 1/10/1983, what is this?
This is, my lord, his date of regularization, my lord.
Regularization.
Regularization, my lord.
1/10/1983.
This is the, yes, my lord.
And date of appointment?
No, so, my lord, this is the date of appointment, my lord.
Date of appointment, my lord.
This is the entry into service, 11083.
So 1/10/1983.
Yes.
And
my lord,
my service was regularized, my lord.
No, do you dispute this date?
My lord, and
Date
he
of
retired on
entry,
3/1/24.
Date of entry in service.
Date of entry is 3/1/24 is retirement, meaning thereby he has served for 40 years.
1/10/1983 is what?
Entry.
My entry into service, my lord.
Your entry into
First entry.
Now, if you go by the date.
Prior to that, I was a master worker. Thereafter, I was regularized.
Now, if you accept the date as 1/10/1983, and if you also accept the date available in your what is this called service book,
right?
Your age on the date of joining is 13 years.
13 years.
How can you join 13 years in government service?
No, they have to reply against that.
Huh?
They have engaged me as a master
How
worker.
can you be engaged at the age of 13?
Yes, my lord, there is a boy service, my lord.
What service?
Boy service, my lord.
Boy service?
My lord, it was, I have found in the records of age, my lord, in another case, my lord.
কোথাও রেগুলেশন তো দেখবে না কাউন্ট করলেও তো হেঁটে ডেট নেই My regulation order, Annexa B, page 23.
So your date of retirement was reflected there on 31.
Reflected, my lord, 31/1/2024.
And when were you released?
My lord, my release order at page 29, Annexa F. 31/2024. 301.
No. So on the day you were regularized in 2005, you knew that your date of retirement is 31/1.
24. Yes, fine.
Then why have you waited for all these years to?
Yes, I have explained in my government.
Where is, what explanation?
Yes, fine. Yes.
Where?
At Parai, page 12.
No, this is after you are released.
Yes.
We are asking you that on the day you are regularized, you have been served with a copy of this order, Annexure B, page 23. You have enclosed to the writ petition.
Yes,
This,
my lord.
this order reflects your date of retirement to be 31/1/2024.
Petitioner read only up to class 7 or 8, my lord. He could not understand the meanings of that order, my lord. It is in English, my lord.
So who explained to him that he is retired? If he is illiterate, somebody must explain to him that from tomorrow you're not supposed to come to office.
Yes, my lord, but they have never asked me any explanation by showing any notice, my lord.
But you have to explain what we are doing from 2005.
In 2005, in its
you
regularization
knew
order,
that-
madam. It is
Now, what is the date according to you?
My lord, my date of birth is showing, and my lord, in my reply, lordship may kindly turn to my affidavit in reply, my lord. We have also annexed one document there, my lord. A serial continuation page number 43, annexure 1, salary certificate. In my reply affidavit. It is issued by the respondent number 3.
Which one? Serial number? Page number?
Page 43.
43.
Salary certificate. In my reply.
Yes.
Service particulars. Data post health, sericultural regular MR, date of birth 31/3/1970, date of joining, it is after regulation 22/7/2005, date of retirement 31/3/2030.
Where is the notice that he is to be sent on retirement?
notice at page 29, Annexa F.
This is for release order.
My lord,
This is release order. Prior to that, no notice.
no notice.
Now, Mr. Dhar, there has to be a notice.
And my lord, prior to retirement, my lord, they have prepared my pension papers, etc. also, prior to 6 months of retirement.
Hmm. His service book reflects a particular date of birth. Now, you disbelieve him on what ground?
My lord, here is a regularization order that I have in a service book, the original document, my lord. That reflects, my lord, his date of retirement is 31/1/24. My lord, the department will go, my lord, date of entry and date of retirement. My lord, that was incorporated in his regularization order. My lord will find in page 23.
He's entitled to some notice that he has to go on retirement on so and so date. Something must have been issued.
Even assuming that my lord, if we calculation is 60, then that is not my retirement date. Even assuming.
Yes. What does the FRSR say?
3 years. He has to raise this correction of, if there is any ambiguity, my lord, he has to raise it before the HOD 3 years prior, my lord, to the date of retirement.
But they have not asked me any show cause notice, my lord.
My lord,
Yeah, you are aware of these orders. You should have corrected these orders.
2005, he knew, my lord, his
Your
regularization order, my lord, in page
2005
number
order
23.
says you are appointed on so and so date.
In page number 23, my lord, the writ petition. That is crystal clear, my lord.
Even assuming that my lord, it is not my date of retirement, my lord. If as per their calculation, I have to retire at the attaining at the age of 60 years, my lord. And my service book
No,
date
that
of
time it was different.
it was 58 years. That notification is there. After 1 year, that another 1 year.
Hmm.
How they calculated that the date of retirement in my regulation order? On what basis?
If you come to page number 25, what is the difference between what will be the age on his date of retirement?
If you go by, my lord, date of joining is 1/10/1983 and date of retirement is 3/1/24, we can calculate the total service period in between is 40 years and 2 months. Already he has served.
When did he join? When was he appointed?
That is his entry into service is, my lord, 1/10/83. And regularization is 14/10/2005.
No, so why his retirement age is 41 years? At 41 years? After 41 years? What would be his age?
My lord, the department has calculated something around 19 years, my lord. 19 years. His entry, my lord.
But there has to be a notice, he's required to be put to a notice so that he knows that he's retiring. Yes.
Yes, my lord, I am praying for crossing of my,
How you can pray for quashing merely on?
because my lord, as per record, my lord, my date of retirement will be fall in the year 2030.
What is what basis are you relying, are materials are you placing before the court? Other than a particular date mentioned in your service book?
Yes,
That's
my
all.
lord, then NHR, I have, in my reply, I have enclosed one document, my lord.
That is salary
Salary
certificate, they may have taken it from the service book.
It
And
is a
that is in the
But
under.
do
My
you-
lord, then produce them,
District.
dispute, do you
then my
dispute?
lord, produce them my service book, my lord.
My lord, service book will not determine because service book is
Because
my
my
lord
lord, there
kept
will
in
be
the
entries in the
district office,
service
my
book,
lord.
my lord.
In
I
the
am-
district office, my lord.
I am making
lord, we-
statements, my lord,
My
specific
lord, government and
statements.
accountant general will go by.
Is all right, but do you dispute these dates which are reflected in your order, regularization order, service orders?
My lord,
You are
I have
aware of it.
enclosed my school certificate, my lord.
Then why did you not get it corrected?
Annexure 1, page 22.
What about page 25, Annexure C? It reflects your date of retirement.
My lord, even assuming that, my lord, that calculation is not correct. My data.
We are not here to correct it, but you should have raised this before the appropriate authority at the appropriate time.
My date of retirement not on 31/1/2024, my lord. As per that calculation also.
Did you
even
raise it
assuming-
before the authorities? No.
My lord,
Have you raised this before the authorities at the appropriate time that these dates are incorrect? No.
probably
After your retirement, you have come before this court by filing the writ petition.
after receiving the notice, my lord.
No, this is not notice. This is a
Release
release
order.
order.
So, sorry, my lord.
Release order.
Release order. And I have immediately thereafter filed representation, Annexure Z.
You want a dismissal today or some other date? On these grounds, we are not inclined to allow your writ petition. Not on these grounds.
But my lord, record shows that
What record?
my date of birth, my lord.
What record? Service book?
My lord, service, let them produce service document.
What will be revealed from the service book? Your first page from the service book is already there, but you accept your date of appointment and you don't accept your date of retirement in the office order. All right, we'll come back at 2.
Fine.
Yes, have you? What item was this? 63.
Take a chance and wait because I think another 15-20. In any case, I'll have to watch the proceeding. I'll sit here and watch it. It's
You are
going
he is
back
for
to
the
guest
petitioner.
He is associated with me as a local. council.
Okay.
I'll
And then
wait,
the-
Your Lordship.
Then another may be given in my item.
Hmm?
Item 51, my lord, then another that may be given.
My lord, substantial time has been.
Item 51.
Yes.
Yes, my lord. Regarding my lord explanation, my lord, your lordship may kindly peruse para 4. Page 8.
No, between a particular entry in the service book and the official orders issued by the department, what is wrong if the department relies on the official orders issued? How do you say that the reliance on the official orders are incorrect?
And my lord, lordship may kindly peruse para 4, my explanation.
Writ petition?
Any writ petition. Page 8.
Yes. Yes.
Yes, my lord. May I read, my lord?
Yes.
That the petition begs to state that as per the office record, he had joined Indus Agriculture Department on 1/10/1983 as a master roll worker found in the extract received by the petitioner, in which the date of retirement of the petitioner wrongly shown as 31/1/2024. However, the petitioner never compared his date of birth against the date of retirement by taking 60 years as his superannuation age.
No, this explanation is all right, but you have accepted your appointment order, your regularization order, where it
my
is
lord,
clearly reflected the date on which you are appointed now.
My lord, in the regulation order, my lord, that from which record they have entered that.
But you have to raise this question before the authority at the appropriate time. You did not. You sat over it.
But from where they have got my retirement date? My lord?
From the official orders. You challenge these official orders. You did not challenge all this. These orders clearly reflect.
And my lord, retirement notice come to the retirement notice, my lord.
They have taken into consideration the date of entry and they have calculated the date of retirement.
My lord.
This was available with you.
My lord.
You
But
did not
as per
raise.
my date of birth.
You did not raise. Your grievance is that you are not supposed to. You were not required to be retired on the date on which you were retired, superannuated. This is your grievance, not date of birth.
Right.
You did not apply for correction of a date of birth.
My lord.
Your grievance is that as per your calculation, you should not have been superannuated on this date.
On 24.
This date was known to you since 2005 at least.
My lord. But my lord, I am not well conversant with the English terms, my lord, but I have explained that, my lord.
You don't know that you have signed the affidavit. Your affidavit is in English. You have signed it.
Yes, my lord, that I have explained to my client, my lord.
What can be done now? Correcting the date now to put you back into service is not possible.
And my lord, retirement notice, my lord.
Retirement notice is also not mandatory. Then
Huh?
merely because it is not served doesn't mean that you have any right of continuing in service merely because notice is not served. There are judgments to that effect.
My lord, on the very next day, they have stated, my lord, I
There are
have,
judgments. It
that
is a part
order
of,
was issued on
I think it is
31/24.
either in FRSR or in the pension rules it is there.
But my lord, no time was given to me, my lord. Notice
You
was.
show us from any rule that you are entitled to a minimum period of time.
Yes, my lord, then my lord, allow me some time.
What were you doing for the past 1 hour? We are hearing matters, Mr. Counsel. Why do you presume that whatever questions the court puts to you, you'll be given a date for reply? You are the one who has got this matter listed today fixed for hearing. Urgency.
Yes, my lord,
Ah.
I am in starvation, my lord, for long.
Yes, we have heard you, heard counsel for
But
parties
my lord, regarding the notice part, my lord.
disposed. We will pass orders. This is item 51.
Item 52.
Yes.
May I please, Lordship? Lordship, in this case, I'm challenging the dismissal order dated 2020, my lord, which was passed pursuant to the civil proceeding, my lord. I'm challenging here, my lord, that this order is passed in violation of statutory rule as well as principle of natural justice. Violation of principle of natural justice, my lord.
Yes, where is the order? Where is the charge sheet? Memo of charges.
Lordship will find a impugn order at page 75, my lord.
75.
This is the dismissal order, my lord.
Yes.
That was passed by the disciplinary authority pursuant to the so-called disciplinary proceeding, my lord. Lordship, Lordship, in the case of imposition of penalty, my lord, Rule 9 of Assam Service and Disciplinary Appeal Rule is mandatory to be followed. Mandatory to be followed, my lord. But in this case, my lord, that was totally allowed to go by.
Where is the memo of charges?
Lordship will find the charge
My
sheet.
lord, before we continue, my lord, this matter, my lord, record may be called for, my lord. Another date may be fixed, my lord. I will, my lord, record is required, my lord, in this matter, my lord. My lord may fix any date, my lord, after 10 days, my lord. In the meantime, I will get the records.
Lordship, in fact, my lord,
This is
in
the
this
difficult
case,
for
my lord,
What is your ground for challenge here?
because Lordship, basic ground is the Rule 9, provisional rule and not at all follow, my lord.
No, not at all means in what sense? Where you
Lordship,
served with a
in
memo,
this case, my lord,
where you served with a memo of charges?
yes, my lord, but
Did you reply?
my lord, that was not, no time is given to me to reply, my lord.
Where is that?
Lordship will find us at page, my lord, 64. my lord. Lordship kindly take a note 63.
63.
63.
63.
63. This is the order issued by the chief engineer PWD roads, my lord.
Appointing inquiry officer.
Lordship.
Then you are served with a show
Lordship,
cause.
then Lordship will find
64 is the show cause.
So cause, my lord.
Where is the reply?
Lordship, I seek time, short time to file reply, my lord. Lordship will find 67. Lordship will find the, if you Lordship will go by the, peruse the show cause notice, this is mandatory as per Rule 9(2), my lord. The list of date, apart from statement of election, list of witness, a list of date to mandatory furnished to the delinquent officer, my lord. Possible to find there is no list of date, no list of witness. Whereas in the ex parte proceeding, my lord, total 40 notes of document were adduced and that was taken into consideration, and total 9 witness was examined, my lord. And disciplinary proceeding was conducted in my absence without notice, my lord. That is ex parte, my lord. And more so, my lord, it is settled law that, my lord, disciplinary cannot be a witness in, whereas in the instant case, disciplinary himself testified to be a witness in before the inquiry officer. So, in the inquiry report, my application, which was at page 67, was placed before the IO, that was never taken into consideration. And inquiry officer gone for expertise inquiry. And even and further, if you lordship will peruse the inquiry report, there is there is no search regarding rule 15 and 21 of Assam Services conduct rule, but that was held to be violated by.
Where is the appellate order?
Lordship appellate order at page 108.
08.
That was also passed without the mandate provided under Rule 23 of Assam Disciplinary Service Rule. There is no independent application, no independent finding, only on the basis of report called by him from the subordinate officer and passed the speaking order.
Where is your appeal memo?
Lordship will find the appeal memo at page 84 to 104 million, an extra 28 million. I have stated details for which was took place in the disciplinary proceeding, but that was never taken into consideration by the appellate officer. In fact, that appeal was referred before the special commissioner secretary, commissioner and special secretary, but Lordship will find the appellate order was passed by the chief engineer. Perhaps it was delegated to him. Whereas inquiry was initiated by chief engineer himself, my lord. So normally, as per Rule 9, my lord, if disciplinary authority desire to intends to impose punishment, there should be an inquiry as per the procedure provided in Rule 9, my lord. Here, my lord, inquiry committee was constituted earlier, then my lord, show cause notice, and that too without material which to be supposed to be adduced before the in support of search, my lord. That was never. And whereas in the expert inquiry, my lord, all the materials, all the witness were produced, and that was behind the back of the petitioner, my lord. And no opportunity was given. And more so, my lord, since major punishment is, and apart from that, lawsuit, if the lawsuit will go.
This 108 is the appellate order.
Yes, my lord.
And where is the dismissal order?
Dismissal order is, my lord, page 75.
25.
Lordship, as per rule, my lord, the disciplinary authority has to consider and record his independent finding, my lord.
Your disciplinary authority is the executive engineer.
Yes. Yes.
You said chief engineer.
Chief engineer, but appointed inquiry officers officer is appointed by the chief engineer.
That is a different thing.
Lordship. And Lordship, in the inquiry report, my lord, normally it is a not duty of the inquiry officer to prescribe the penalty that to be imposed upon the delinquent government servant, my lord. But in the instant case, my lord, inquiry officer himself recommended for penalty under Rule 7.
Mr. Dhor,
My lord.
just 1 minute. Mr. Dhor, in the appeal which has been filed,
My lord.
there are specific grounds urged that he was not furnished with the documents, list of witnesses, etc., etc. In the appellate order, there is no finding on that. If you come to page 100, para 2, para 3, page 2, আনিব দিলো, নানিলে।
My lord, that is why I said, my lord, the records may be called, my lord. Correct, record will reveal, my lord, whether the orders, whatever the documents, my lord, is short for, whether those were given or not, my lord. That is why, my lord, I wanted to
One more aspect, my lord.
examine the
Let us
record.
call for the records because you are putting to challenge the disciplinary order, dismissal order, appellate order.
Record will be.
Are you challenging the proceedings also?
Lordship, there is a, yes, my lord, I have. Lordship, in fact, there is a no search under Rule 15 and 21 of Assam Services and Conduct Rule, my lord. Whereas finding of the inquiry officer that the petitioner violated by this act, violated under Rule 15 and 21, whereas there is no search.
No what?
No search in the search sheet, my lord.
No charge, okay. All right, heard counsel for parties. The writ petition has assailed the order of dismissal passed by the disciplinary authority as well as the confirmation of the order passed by the disciplinary authority by the appellate authority in the appeal filed before the appellate authority. Stop. Although pleadings have been exchanged, the records pertaining to the departmental proceedings would be necessary.
Lordship,
Would be necessary
GP
for payment
number-
of the court. The standing counsel PWD is directed to procure the records and place it before the court for perusal if the need arises, if the need so arises. On when can you do it?
As per lordship.
4th November?
4th November, my lord, will be too early, my lord. After 2 weeks, my lord.
So it is 2 weeks only, no? All right, 13 November. 13 November.
13th, my lord.
13th.
Means, my lord, 11, 12, I may not be here, so my lord, I may go to Kohima once, my lord.
11, 12, we are not there. It is on 13.
My lord. Yes, okay, my lord.
You get your records prior to 11, 12.
My lord, oh, my lord.
and We'll proceed in the matter. Yes.
Will kindly see page number 23. 23, my lord. The petitioner, my lord, was appointed as a peon, my lord, in the Department of Sericulture, and he was posted under Superintendent of Sericulture, South Salman, Hatsing, my lord, in the year 2015. Thereafter, my lord, after completing 7 years of service, my lord, lordship will kindly see page number 29. He submitted a representation, my lord, to proper channel that he he was graduate in arts and also had a diploma in computer. And was seeking promotion from grade 4 to grade 3. It was done in the year 2023.
Which department?
Sericulture, madam.
Sericulture. Thereafter, my lord,
Are you also governed by that personal post?
No, madam, this is different.
This is different,
It's a direct entry, madam.
direct. Then
thereafter, my lord, in the year 2024, my lord, they initially published a provisional gradation list. And after around 15 to 30 days, my lord, they published a final gradation list, my lord. Lordship will kindly see page number 38. 38. At serial number 88. In the final gradation list, my lord, his educational qualification, my lord,
38.
38, serial number 88. In his educational qualification, my lord, BA was mentioned. That means it was up to date. But regarding his diploma in computer, my lord, that was not reflected, my lord. So we submitted a representation that you verify our documents and modify this gradation list to that extent, my lord. But that was not answered, my lord, and that's why, my lord, we filed this instant petition, my lord. Our only limited submission is that, my lord, we do not see promotion, but at least his diploma may.
Where is your representation?
Representation is at, my lord, page number 11, my lord, 56, my lord. 56.
56.
56. It was submitted on 25th July 2024. Wherefore,
Sericulture.
yes, inclusion of computer diploma certificate course in gradation list of grade 4. That is our limited prayer, my lord. Let the document be verified, my lord. If it is found to be genuine, my lord, then
But this list is prepared on what basis? Seniority list?
yes, gradation
list.
list.
Gradation list, madam.
Where is that gradation list?
At, it starts from, my lord,
32.
page number 31.
No, 31.
31.
So your name appears at 38.
Serial number 88. Page number 38, serial number 88. This BA education qualification, this BA was modified, but computer diploma, my lord, it was not up to date, man. That was not
No, this is the final gradation list.
final.
Where is the provisional?
Provisional, my
gradation
lord, we could not lay our hands on, my lord. We did not know about that provisional list. That is one issue, man.
My lord.
But there is an averment here in the affidavit. And it says that you did not submit any objection.
Yes.
And moreover, my lord, he never disclosed his computer skills, that certificate during his appointment, my lord, during, my lord, his applications made for the, my lord, job, my lord, nothing. Suddenly, my lord, after 2024, he comes up, my lord.
No, we submitted the representation back in the year 2023, before this gradation list was
You
prepared.
dispose of, consider and dispose.
Yes. Let them consider, man.
Heard the counsel for parties.
Following due process, of, my lord, we will follow the law, my lord, whatever it is.
The petition is filed with the council. Limited prayer of the petitioner before this court is that in the final gradation list, which was published on 20 July 2024, name of the petitioner appears at serial number 38. 88. So the petitioner is presently serving as a peon in the office of the
Superintendent of Sericulture.
Department of Sericulture, posted at Hatsingimari, the district of South Salmara. The petitioner is agreed that insofar as the educational qualifications the petitioner is concerned, besides being a graduate, petitioner had successfully completed, within quotes, advanced diploma in computer application, bracket close, the year 2011-12. So these credentials were submitted to the competent authorities in time, but which are not reflected in the final gradation list in so far as the petitioner is concerned. So It is the submission of the council for the petitioner that under, you are governed by what rules? District,
Yes, madam.
ministerial? No.
Ministerial rules.
You have a set of rules,
Yes, my lord, district ministerial rules, my lord.
ministerial. The district
the matter.
ministerial rules, 1967, I think. Governs the services of the writ petitioner and which is not disputed by the respondent council. So pursuant to an amendment carried out in the rules. What is the percentage of promotion? 10%.
10%, madam. Yes.
10% of the post in grade 3 are to be filled up by promotion from grade 4. Stop. The petitioner submits, the learned counsel for the petitioner submits that he has rendered sufficient years of services to be considered for promotion to the next higher post of grade 3 under the rules. And also the fact that he has completed the advanced diploma in computer application may be a pertinent ground for the authorities to, which may be considered by the authorities at the time of his selection for promotion to the next higher post. So, learned counsel for the petitioner submits that pursuant to the publication of the final gradation list, the representation dated 25/7/2024 was filed requesting for correction of the same. Stop. The same has not been redressed and therefore the writ petition is before this court. Where Mr. Ardhor, the additional senior government advocate representing the department, submits that there is an affidavit filed on behalf of the department where it is stated that within the prescribed period of within the period prescribed after publication of the select list, gradation list, no objections were received from the writ petitioner. So, whatever data was available in the office of the superintendent of sericulture in Hatsingimari, under which office the petitioner is presently rendering service, all these data have been incorporated in respect of all the incumbents, including the writ petitioner. Stop. Mr. Dhor submits that this particular document has been furnished subsequently and that too directly to the office of the Deputy Director Sericulture. Stop. That are having considered the submissions made by the council for the parties and upon perusal of the pleadings available on record, is seen that the petitioner has submitted a representation dated 25th of July 2024, ventilating his grievances. Stop. The averments made in the affidavit also does not dispute that such an representation was filed. Stop. The only ground for non-consideration is that these information or data reflected in the final gradation list are on the basis of the data received from the office of the superintendent of sericulture, Singimari, in the district of South Salmara, namely the establishment under which the petitioner is rendering service. Stop. This court is of the view that if the petitioner is indeed successfully completed a certificate course within court's advanced diploma in computer applications post closed, and it is and the petitioner is required to, and the same is required to be reflected in his service book or documents maintained in the administrative office, the same should not be denied. Stop. Under such circumstances, this court is of the view that the writ petition, in considering the limited prayer made, writ petition is disposed of with a direction to the Director Sericulture to examine the matter reflected in the representation dated 25th of July 2024. And if the same are found to be correct, the necessary changes may be made in the office records maintained by the administrative office, including such changes as may be felt necessary in the final gradation list published on 20th of July 2024. Of such changes as may be found by the department may be incorporated appropriately insofar as the writ petition is concerned. Even
My lord,
it is found that the prayer made is not, it is found that the claim of the writ petitioner is not based on valid documents, then an appropriate speaking order be issued by the director. And a copy thereof shall be served on the writ petition. Let this entire exercise be completed within a period of 30 days from the date of receipt of certified copy of this order.
My lord, I only pray for only one observation, my lord, that during the time of his application and my lord, during his appointment even, he never claimed that he has a diploma certificate.
No, it is after his appointment.
After his appointment, my lord, but he claims that he had this
No, we
document
have
prior
recorded-
to his.
No, we
to
have
the-
recorded it. Whatever is there in your affidavit, we have recorded in the order that the data available, data published in the final gradation list is called from the office of the superintendent of sericulture where he was working. As per the data available.
May I please? Lord, the petitioner sir, my lord, deployed as my lord homeguards. Petitioner sir, my lord, deployed as homeguards, my lord, after passing the training, basic training of homeguards, my lord. After serving, my lord, 6 months, my lord, they have been discharged from their service, my lord, without any notice, my lord.
They have been?
After 6 months, my lord, they have been discharged from their service, duty, my lord. My lord, as per the, my lord, the training for certificate, my lord, I have annexed at page 20 and 21, answer 5 and 6. Here, my lord, they have passed their, my lord, training, both they are found physically fit, my lord, to work as homeguards for another 3 years with effect from 1/1/23 to 31/12/25, my lord. And after issuing this service, my lord, they were on.
No, is there any rule or provision that you are bound to be given regular, you are bound to be deployed regularly?
My lord,
It is on a need basis.
my lord, since my lord, we have been replaced by other persons, my lord. That is our difference. And not on last occasions, my lord, Testament number 3 has filed evidence in opposition, my lord. And where they have taken the stand that homeguards are deployed only for 6 months. So on last occasion, my lord, the Honorable Court asked them to file additional affidavit to bring on record where from they have made that assumption, my lord. Order dated, my lord, 18/8/25. They were asked to file, my lord, on additional affidavit.
Where you show us the act, where is the provision of the act and the rules?
The rules is there, Lordship. We have the statutory rules. It is specifically mentioned that seven.
Where are the rules?
Yes, Lordship, this is the rule, Lordship.
Give us the rules.
Yes.
The rules are made under some act.
Yes,
the
Lordship.
309
Yes.
rules.
Yes. The rule under the Assam Home Guard Act, Lordship. Lordship, section 7(2). It is categorically stated that one shall serve a home guard for a period of 6 months, which period may be extended by the state government to a total period not more than 12 months if the government considers such extension necessary, Lordship. It means it is up to 6 months, Lordship. If necessary, it may extend.
What happens after that? After
Lordship,
6 months, what happens?
Yes, Lordship. If required, Lordship, time to it.
If not required, what happens?
Lordship, it is a reserve force only. Is a
I'm asking you,
trained
what,
reserve.
what happens? They go back home.
No, Lordship, they are reserved in their home only.
So as and when required,
Yes,
they are
yes, Lordship. Yes.
This is the rules.
My lord, rules says, my lord, they may extend, my lord.
May extend, may not extend. You have to show materials that your extension was not given by the authorities for reasons not germane, not bona fide.
My lord, our grievance is that, my lord, they are, my lord, deploying the people on pick and choose basis, my lord. After 6 months, my lord, they pick up other people's, my lord. Giving us chance. That is our grievance, my lord.
How do you determine the need basis?
Lordship, Lordship, it is as per the necessary, Lordship, if required.
What necessary means what? We are asking you.
Yes, Lord.
We want you to enlighten us with some practical examples.
Lordship.
Supposing the petitioner is where are you? You're a resident of which?
Same district, my lord.
Huh?
My lord, from Sribhumi, my lord.
From?
Sribhumi.
Sribhumi. Now, the need basis must arise within the district or subdivision or what? What is the criteria?
Yes, Lordship, it is paragraph 3 of my affidavit, Lordship.
Your paragraph.
Page 25.
Paragraph 3.
In my
says
affidavit, Lordship.
You offer no comment.
No, Lordship, I'm sorry, Lordship, it is 4, Lordship. Paragraph 4, Lordship.
Yes.
That with regards to statement so and so and so, the relevant portion I would like to read over that the petitioners are the home guard volunteers, home guard who are engaged in duty for a period of 6 months each under the Assam Home Guards Acts and Rules 1947 amended in 2015. They are also given training in basic, refresher, advanced leadership, etc. as per their willingness. In the matter of engagement for duty, it is done as per the requirement or vacancy of the utilizing department of like agencies. They can remain as active home guard volunteers in reserve for a period of 3 years. The authorized strength of the home guards volunteers of Sribhumi, then Karimganj district is 1,160. 60, and out of that only 102 are deployed as per the requirement under Sribhumi district. Therefore, all the home guards volunteers cannot be deployed for duty at the same time. Moreover, currently the home guard volunteers are deployed for a duty through the Home Guard Department System HGDS, where the home guards volunteers received deployment through an online software system by auto-generated command certificate depending upon their land and seniority of their release from the duty in a rotation manner, Lordship. Out of 1,160 only 102 is the requirement, Lordship, are the requirement, Lordship. Now, Lordship, when the turn of the petitioner will come, he will automatically get. This is the system, Lordship.
When was the last time you were engaged?
My lord, February 2014 to July 2014, 24 months.
Long period he
This is beyond 3
spent
years.
in duty. Yes, long period he spent.
My lord.
You were engaged beyond 3 years.
No, my lord. From February 2024 to July 2024 for 6 months. Petition number 1.
This
and
is
petition
what the
number 2, my
rules
lord.
say. What this is what the rules say.
My lord, their requirements is there, my lord.
Their statement will not do. You show us from any document, anything, any material to show that there is a requirement, or they are adopting to pick and choose method as per their whims and fancies.
My lord, my learned friend has already, my lord, stated that the requirement is, my lord, 100.
102
102
out of
They are
1000.
engaging people on rotation basis. my lord.
Yes.
So this process, my lord, they are, my lord, taking the fuel on pick and choose basis, my lord. We are senior
So
most, my lord.
mayor's statement will not do. You have to bring up some material to show. Mayor's statement that pick and choose method, you have been working from 2014 to 24.
No, my lord, not 20.
Then
14, my lord, only for 6 months, my lord.
6 months. Was that on a pick and choose method? How were you picked up?
My lord, we were, my lord, we appeared before the, my lord, session committee, my lord. We appeared before the session committee, my lord, at page, my lord, 20, SR 5, my lord. The district commandant, my lord, had issued the certificate to us, my lord.
How do you decide? How do you choose the home guard, Mr. Goswami? On what basis? Who decides? What is the parameters for deciding the necessity?
Yes, Lordship, necessity, it is decided by the authority, Lordship, but
So there must be on some parameters.
yes, a parameter is there, Lordship. It is paragraph 4 is very clear. Throw a auto-generating system, Lordship.
Oh, that is for informing these people. That is for informing.
Yes, Lordship.
Depending on their length and seniority, released in rotation basis.
Yes, Lordship, requirement is 102. We have in reserve are 1160. He released only
So
on
you are
24.
saying-
Only
you are
on
saying-
24.
You are saying that 102 home guards.
Yes.
Are being deployed on a rotation basis through this online app.
Yes, Lordship. Yes. Only he released in the year of 2024, Lordship. Other have to get the chance, Lordship. That we have 1160 is our reserve in reserve, and one troop, one batch will continue till 6 months, Lordship. After that, another batch will come.
You give us some materials from your records to show how this rotation is put into effect.
Lordship. Lordship.
Give us some materials.
But this is not his right, Lordship.
No, he does not have a right to be appointed, but he
yes.
certainly have a right to be considered fairly.
No, look, Lordship considers
whether his case has been considered fairly. You'll have to show us.
Yes, but he has no such type of allegation to ascertain that we did some anomalies, Lordship. For
So
choosing.
we want to know, we want
Lordship.
to be satisfied that
Lordship,
this
Lordship.
statement that
I
you're
will take.
making
I will take.
is supported by something.
Yes, Lordship.
Heard counsel for parties, the learned government advocate will furnish before the court. Because in terms of the earlier order, the learned government advocate has produced before the court copy of the rules governing the services of the Home Guards in Assam, being the Assam Home Guard Act and Rules, 1947. Agortu has produced the rules to Gatidio, has produced the Assam Home Guard Act and Rules, 1947, where at para 7 within bracket 2, it is prescribed that a home guard shall, after training, serve for a period of 6 months, which period may be extended by the government to a total period of not more than 12 months. And if the government considers such extension necessary and shall thereafter serve in a reserve for a period of 3 years, and while in reserve, they shall be liable to be called out for duty anytime. So, the learned government advocate has also referred to the averments made in the affidavit that there are 4 to submit that the deployment / redeployment of home guards are done on a rotation basis by resorting to an online software system which auto-generates command certificates depending upon the length and seniority of the release from duty. So, insofar as the Sri Bhumi district is concerned, the total number of home guards is 1160, and as per the competent authority, the requirement is only of 102 home guards. Stop. Para. Although the averments made in the government, in the affidavit filed with the government, are referred to by the council. However, the same are not supported by any official, by any materials. Stop. We permit the government advocate to place before the court any relevant material to support their contention that the deployment of home guards are being done on a rotation basis by official, by an online software, and these specifications mentioned in Rule 7.2 are being consistently followed. List after 2 weeks.
Lordship.
Item 65.
May I please, Your Lordship? My lord, brief is today fixed, and I have been asked to bring one Ajay Chaudhary's judgment, my lord. Here is the case, my lord, in the nutshell is that, my lord, while petitioner was working as a superintendent, my lord, and he was placed under suspension by page number, my lord.
What
By
is the
page-
status now here?
My lord, 31st 5, my lord, I am already retired. And my monetary
So
benefit.
what has happened to the proceedings?
Lordship, on last 2 days, he preferred not to attend the proceeding, Lord. On last 2 days,
The proceedings are pending.
DP is pending. On last due date, he was issued summon on last summon was on 10/9/2025. And the date and time was 29/2025 at 12:30, but he preferred not to appear, Lordship.
So what is your challenge here in the writ petition now?
Challenge is that, my lord, lordship kindly turn to page 37, man.
Suspension order is gone.
Yes, my lord, suspension, I was placed under
Reinstatement is
suspension.
gone.
Thereafter, my lord. Thereafter, my lord, I have been issued a show cause reply, my lord. Show cause notice, I have replied, my lord. Then, my lord, they pass another order, my lord, which I have brought into record by way of filing a additional affidavit, my lord, that your lordship will see.
No, let us come to, please come to page number 25 of your writ petition.
It is my prayer, man.
Yes, so your prayer is for setting aside quashing impugn suspension.
Yes.
That is irrelevant now.
Suspension and
Then
then, my
directing you
lord,
to
be
pay
directing
allowances.
the respondent to pay all the allowances
So
to the petitioner without
alright,
any further.
B is subject to the departmental proceedings.
My lord, that I'm coming, my lord.
Then C is for reinstatement, that is also gone.
That is gone, my lord.
Then
D,
is to consider the representation.
my lord. That is fine.
What representation?
Annexure 11, my lord, that your lordship will see at page.
This
at
is for
page 43.
reinstatement. This is for reinstatement.
No, my lord, in
Yeah.
view of the above, it is earnestly prayed before your lordship to look into my grievance
To
sympathetically
reinstate me.
and also prayed your esteemed authority to reinstate me in the service, considering the superannuation on 31st first. Also, so and so, but during that time, my lord, when I filed the writ petition, my lord, he was on service, my lord, the honorable
Maybe,
court
but today.
issued notice.
So today, these prayers have all become redundant now, except for a prayer that your disciplinary proceedings should be expedited and completed. So that unless you challenge the proceedings are not subject matter of this writ petition.
No, my lord. That time, my lord, I challenged suspension. And secondly, my lord, on the various occasion, the cases was listed before my retirement.
Whatever it may be, but
My
as
lord.
on date, you
As on date, I am on retirement.
retirement. So as on date, we are required to decide what orders we can pass.
My lord.
So we can only pass orders perhaps with regard to your prayer number B and partly prayer number, no, only B.
B.
For payment of all allowances, which
Well-
will be subject to the outcome of the departmental proceedings.
May I pray one thing, my lord? Lordship, give me some days time, man. I'll call on my client and we'll withdraw it. We'll file appropriate writ petition challenging all this thing.
So why do you want to trouble your client? We'll expedite it by dismissing it, giving you liberty.
Lordship, kindly give me 3 days time, my lord. Nothing will happen.
The third counsel for parties, the for the petitioner takes liberty to complete his instructions as the writ petition essentially was filed putting a challenge to the suspension of the writ petitioner and for seeking a direction for reinstatement in service and also for payment of his subsistence allowances and other allowances as may be found due. Stop. During the tendency of the writ petition, petitioner superannuated on
31st, 5/25.
31st.
31st, 5/25.
So 31/05/2025. Under such circumstances, the writ petition has effectively become redundant. The prayers made in the writ petition have become redundant except the prayer seeking a direction to pay allowances to the petitioner with effect from 18/1/2025. So this prayer, however, will again have to be made subject to the outcome of the departmental proceedings, which are stated to be underway against the writ petitioner and are presently pending. So, at the request of the counsel for the petitioner, to complete his instructions, we permit the writ petition to, we direct the writ petition to be listed next week.
Next to it,
Next week.
next to it.
Supplementary list, so admission item 67.
May please, Lordship.
Your Lordship, may kindly pass over the matter for time being.
What time being, we had fixed it today.
Yes, madam.
Lordship, he's on legs in another.
No, that is the ground you mentioned on the last date. We had accommodated you. What is the grievance here?
Yes,
Height?
my lord. Petitioner, my lord.
Is it a height?
No, my lord. Medical, my medical.
Medical.
But petitioner already appointed, my lord. After appointment and after joining, my lord, he was declared unfit, my lord. That is the risk.
All right, time being, time being.
List for hearing item 66.
May I pray, your Lordship?
Yes.
Lordship, pension matter, Lordship, under old pension, OPS, in the old rule 1969. My lord, similar matter is already decided of the same sub-registry office. In case of the sub-registrar, it is already decided before the single bench repetition was allowed. The state filed a writ appeal after 404 days. Initially, that was rejected. Condonation petition was rejected. State went before the Supreme Court. Supreme Court, however, with imposition of 25,000 cost, allowed that petition, remanding the entire matter to be heard by the division bench of this honorable court. Division bench, in the meantime, on 12/5/2023, dismissed that writ appeal, attaining finality of the entire issue. So, now, my lord, I am his clerk.
Which writ appeal? 73.
73.
What
Now,
was the finding?
writ petition was dismissed, that a pension was granted, and thereafter contempt proceeding was there. And in the contempt also, government was compelled to comply with. And in the meantime, that sub-registrar received his pensionary benefits with area salary. That order is Annexure 8, page 50. But before that, kindly coming to the facts, Lordship, of my case. Kindly take up the writ petition first, Lordship. Already everything is there, even written argument also we have filed. The writ petition, Annexure 2, page 22. May I read, my lord?
Yes.
Notification. Government of Assam, order by the Governor, Registration Department, Dispur. The 28 April 1984. Subject to discharge at the discretion of government, without notice and without assigning any reason thereof, Mohammad Hussain Ali, son of late Waziruk Ali of Post Office Village, Loharkata, District Kamrup, Assam, is hereby appointed temporarily and until further order says commission basis sub-registrar of commission basis sub-registry officer at Mukalmua in the district of Kamrup. Within Kamrup, now it is in Nalwar region. In the usual terms and conditions with effect from the date he takes over service. Second part is very, very vital, Lordship. The newly appointed commission basis sub-registrar will be remunerated in accordance with the provision contained in para 50 of the chapter as per instruction and orders contained in the registration manual. Assam. Registration manual is with me, Lordship. I have given sufficient affidavit also explaining those things. Necessary office accommodation, that is important, Lordship. To be arranged by him at his own cost. Books, forms, etc. will be supplied to him by the Inspector General of Registration, Assam. If necessary, he may arrange office establishment. That is also very, very important because sub-registrar all alone cannot run the establishment, entire establishment relating to this registration of sale deeds, this, that, etc. At his own cost and at his own responsibility. He is not allowed to take any further employment during the period of his incumbency as commission basis sub-registrar. My lord, based on this, there is specific direction to arrange office establishment. Now regarding the post of LD, Lordship Land Division Assistant, it is the establishment of Assam Registration Manual. Both
You are appointed as what?
LD, Lawyer Division Assistant. Why?
LD.
Yes, Annexure 3, page 23.
On what basis? Under what rules?
Because that sub-registry office was sanctioned on commission basis and sub-registrar was empowered to arrange the official establishment. I was also given appointment by the sub-registrar as page 26, my lord.
26.
Annexure 3.
Okay. You were appointed by the sub-registrar. Is he authorized to appoint you?
Because the commission system is as such. Salary basis, the office was converted later on in the year 2007 by taking a cabinet decision, and the entire staff was regularized in the year 2008. Without any sense modification or whatever it may be, entire staff as it is.
Where is it?
That is, Lordship may come to Annexure 5, page 38. Annexure 5 and 6 is very, very crucial. Page 38. May I read, my lord? Government of Assam Registration Department. Orders by the Governor. Notification. 22nd June 2007. The Governor of Assam is pleased to convert the following 5 existing commission basis sub-registry offices into departmental one with effect from the date of posting of the departmental officers and subordinate staff. I am in the subordinate staff. I am not the sub-registrar. The commission system will cease to exist soon after the appointment of departmental sub-registrar and subordinate staff for each of the offices so converted. Name of the commission basis sub-registry office. Mine is at number 1, Mukalma. Now kindly come to turn over the next page 39, Annexure 6. This is very important. 25th April 2008. My lord, one thing, it was a delayed regularization. As per the Assam registration service rule also, 2010 only they have the service rule.
When
So far,
did you superannuate?
I superannuate in the month of January 2015, more than last 10 years. Now it is to be completed 11 months. My lord, as per the regulation, Assam Registration Service Rule 2010, which I have annexed also.
What was the issue before the single judge in which the appeal was appealed?
Entitlement of a commission basis sub-registrar, whether he is entitled to pension under 1969 rule or not. My entire past service, my lord, from 1984 to 2008 is countable for my pensionable service or not. That is straightway, lordship, kindly have a look to page number 62, my lord. Yes, 62 of the, for a moment, for your lordship's kind appraisal. Page 62. Para 33 and para 34. That judgment by my lord justice.
Yes, 62.
62.
Ah.
I am coming to the operative part of the judgment. Pay para 33. Lordship got it?
Yes.
Thus, having regard to the discussions made above, claim of the petitioner that services rendered by him as sub-registrar on commission basis should be included for the purpose of computation of his pensionable service has merit and deserves consideration. Para 34, respondents are, this was the direction. Respondents are accordingly directed to count the service rendered by the petitioner as sub-registrar on commission basis prior to his regularization as sub-registrar on 25/4/2008 while completing his pensionable service and thereafter to grant all consequential reliefs, which I have got. Subsequently, my lord, this order was appealed against after 404 days. I have already told it. After remanding back by Honorable Supreme Court, that appeal preferred by the state has also been dismissed. The entire issue has issue estoppel. Now there is no issue, although state is trying.
It appears to be covered.
No, let him, my lord, let him complete his submissions, my lord.
We'll continue. We just want to know why is it not covered?
Because, my lord, prima facie, my lord, the first and foremost point will be, my lord, the other person, that is Hussein Ali, who was appointed on commission basis, albeit on commission basis, he was appointed by the, my lord, government. And against the decision taken by the government, my lord, that at that point of time, since it was not possible, my lord, on the part of the government to, my lord, set up a full-fledged registered office, my lord. So therefore, my lord, the commission basis registry was appointed. And in the order itself, at page 22, which lordship has just now seen, a leverage was given to that gentleman, Muhammad Hussein Ali, that he may arrange, my lord, his establishment at his own cost. That is of, my lord, paramount importance here. If necessary, he may arrange office establishment at his own cost and his own responsibility. That is the primary distinguishing factor between that writ petitioner and this writ petitioner. And let him distinguish that aspect of the matter.
No. Is there any dispute
Yes.
with regard to the regularization?
No, regular.
Petition?
No.
The entire staff and everybody has been regularized.
Everybody has been regularized.
In the year 2008.
Yes, in the year 2008. Thereafter, my lord, that person, my lord, the sub-registrar who was appointed on commission basis, namely Muhammad Hussein Ali, he laid a writ petition before this honorable court, which have been disposed of. Lordship has seen it at page 62. There, my lord, this honorable court has taken into consideration the basic fact that, my lord, it was a conscious decision of the government to employ that person on commission basis, and having, my lord, directed that person to work as such, and having regularized at a later point of time.
Your objection with regard to the earlier person. What was his name?
Hussein Ali.
Was on the ground that he was regularized in 2008.
2008, but.
And therefore he is entitled to
new pension.
New pensions.
New pension.
The court declined to accept it on the ground of the fact that this was a clear intention of the government to initiate.
Absolutely.
This particular sub-registry.
Absolutely.
Right.
So therefore,
in
it
this
was.
case, your only ground is that these people were not appointed by the Revenue Department.
Revenue Department, by the government.
By the sub-registrar, the then sub-registrar.
That is at his own cost and at his own responsibility.
Right.
So that is one of the
But
distinguishing.
subsequently, they came to be regularized.
No, they came to be regularized, but the honorable court, my lord, the writ court, my lord, the honorable single judge has taken the view, my lord, since it was the government who had appointed him, and it is the same government who had regularized. So therefore, having worked in that capacity, his past services, my lord, has to be counted for the purpose of granting him the benefits under the old pension, that is the 1969 rules. State had put that decision on appeal, my lord, and appeal it was dismissed. Ultimately, that gentleman filed a contempt, and in the contempt, he had got all the reliefs. Now, this is only one aspect of the matter. Secondly, most importantly, which was not placed in that earlier writ petition, my lord, was that whether that person had made any contribution towards the new pension scheme. Thereby, the principles of waiver, estoppel, and acquiescence will come into play. Here, the revenue department had filed an affidavit which could not be controverted as such by the writ petitioner to show and to demonstrate, my lord, that the writ petitioner had made contributions towards the new pension scheme. And having made contributions to the new pension scheme, he cannot now resign. These are the 2 points. Apart from that, there are other points of my argument.
Opted for the new pension.
No, my lord, I have not taken it. Hussain Ali also contributed that irregular illegal undertaking. Hussain Ali also made, I also made.
No,
And
my
that stuff.
I will have
That-
to
that
make,
those
I
things
will,
are
I will have to
on
make a
record.
distinction with all respect to him, my lord. My lord, now, the undertaking has to be given at the time of regularization. That is one aspect of the matter. Pursuant to that undertaking, whether any money had flown.
Is there any finding in the judgment that he did not contribute? The Hussain Ali did not.
Yes,
contribute?
yes, no finding,
No finding.
no finding, and it was not placed even.
The only the ratio of the judgment is that in view of the services rendered
Yes.
and
Services
subsequently being regularized, the earlier services
Has
will
to
have
be
to be counted for pension.
Yes, because initial appointment by government, regularization by government, and retirement under the government.
Here also it is the same case.
No, here, my lord, initial appointment will make the, my lord, all the difference, my lord.
Initial appointment is subsequently ratified by the regularization.
Regularization, therefore,
So how can you regularize somebody whose appointment you are questioning?
No.
Appointment is.
The purpose of the moment you regularize their appointments means that whatever sources of appointment was there has been accepted by the government.
No, yes, my lord, my lord, to put it in other words, my lord, regularization means, my lord, he has been brought into a regular cadre.
Correct.
As
Why would
simple-
you bring somebody unauthorized whose sources of or the manner of appointment was under
That
the
is true.
cloud?
That is
Why
true.
will you bring him
That
in
is true. That is true.
regularization?
That is true.
You know how these people were appointed.
Yes.
It is
Because-
expected that the government will know.
Yes.
So once you bring the entire establishment in regular appointment.
Yes.
And you maybe you have raised objections, you contested, but the court ultimately granted the relief in favor of the sub-registrar.
Yes.
Why the same benefit should not be given to them?
The same benefit because Lordship will kindly see, my lord, and appreciate, my lord, the whole establishment was regularized. And including the staff working thereon. Now, the next issue which will fall for consideration is that, my lord, whether the past services can be counted.
It has been counted in the other judgment.
Yes, in the other judgment, because therefore Lordship will kindly appreciate, my lord, the initial appointment was by the government.
No, that is where you have to give an answer.
Yes.
That if the initial appointment is by the government,
Yes.
and in this case it is not by the government,
Time
but
of-
you
yes.
continue to regularize them
Yes. Therefore,
without any demand.
Yes.
Regularize him.
yes, that is true, my lord.
Now, once you regularize him,
Yes,
you can't regularize people. This is not a direct appointment or regular appointment.
yes,
It is a person working in the same post for that many number of years,
yes,
appointed by whoever, not by
Yes.
the government.
yes.
But you take a conscious decision to regularize it. So therefore, the manner, the procedure in which they have been appointed has been accepted by the government and they
Yes.
are deemed to be regular service.
Yes.
So
Now-
can you now say that we regularize, but we don't take into account the services rendered earlier? How
Therefore,
can that be?
therefore, my lord, Lordship will kindly appreciate, it is not the fact that, my lord, he will not be entitled to pension. He will be entitled to pension, but under the new pension scheme. So therefore,
That issue is already settled now.
No, that is
Because if you can't blow hot and cold insofar as the earlier petition is concerned. On the same facts, you have granted him pensionary benefits under the old scheme. Now,
Because
the
that-
same establishment, maybe you have raised that issue, we don't know, maybe.
Yes, yes.
May not have raised this
That
issue.
issue has been debated.
But ultimately, the division bench has laid to rest
Yes, sir,
upholding
absolutely.
the single
Yes,
judge's order.
yes.
And the
In that,
single judge has very categorically held that the
Yes.
services rendered earlier cannot be ignored.
true, my lord, true.
That
But
has been
there,
upheld.
yes, but there is no finding either in the single judge's order, my lord, honorable single judge order, or in the order, judgment and order of the honorable division bench to the effect that the petitioner therein had made any contribution under the NPS.
There is no finding means the finding is in favor of the petitioner.
No, my lord, those materials were not even placed.
That
Here we are
you-
making, no, my lord, here we are.
Did you urge this issue before the appellate authority?
Yes, yes, appellate
This
authority has
authority-
also dealt.
That, my lord, was not urged.
Then
But here we are urging, my lord, if that will make a whole round of difference, my lord, because once I have made a contribution, I have accepted it, my lord. I have accepted it, and my lord, lordship will kindly appreciate Rule 31, because therefore my entire argument will rest in Rule 31. Rule 31 prescribes 3 conditions, my lord, and those are of paramount importance. Therefore, my lord,
no, there are two different compartments. One is
yes,
they are the services rendered prior to regularization,
yes, my lord,
for which you are referring to Rule 31.
yes,
The other is the option. These are two
Option.
separate compartments.
yes.
So far as Rule 31 is concerned, I think it's not necessary to reopen this issue. It is covered by the division bench judgment. Plain and simple.
The division bench has
The
covered.
question is whether he is now entitled to pay the
Yeah.
old pension rules or the new pension rules. in
Yes,
view of
That has
the
also been.
because Rule 31 was urged before the learned single judge as well as before the honorable division bench.
All right.
But the honorable court has not accepted our argument on Rule 31 because of the fact, my lord, that the initial appointment was by the government and the regularization was done by the government, and the person has retired having worked under the government. Here is a case, my lord, where the second tier and third tier will come under the government, but his initial appointment itself was not ratified by the government. It was not ratified by the government at any point of time, save and except, my lord, by the order of regularization. Save and except by the order of
We'll
regularization.
record your arguments, but prima facie, we are of the view that this issue is covered by the division bench.
Issue as per will come, my lord.
SOPL will not come here, my lord.
Issue as per. Of issue as per.
Because that finding is not there. Therefore, lordship will kindly see the affidavit filed by the, my lord, revenue department. I am representing the finance department, my lord. And lordship will kindly see my affidavit, my lord. Lordship, for a moment, my lord, I am troubling my lord with the pages, my
We'll
lord.
continue on 3011.
Yes. No, this will require some.
Let it
hearing.
be
I will have
to be
to
part
draw
of,
my lord's attention.
my lord.
to be listed on
Yes, my
3011.
30th of this month, my lord. Yes, my lord. Lordship will kindly keep
30,
this.
3030, my lord.
3010.
3010.
Yes, yes.
3010. I have another.
So we have heard you. There's nothing to be heard so far as you are concerned.
I will be.
We'll only have to hear the respondent.
Every issue, lordship, every issue has been discussed in a detailed manner by the learned single bench and division.
So even if you're not available on 30, record your submission.
I will be able.
Yes.
Lordship may be pleased to kindly keep this
Yes,
matter
all right,
part
all
heard. my
Yes,
lord.
yes.
Kindly, yes. I'm so obliged, my lord.
Part heard for further hearing on 3011.
My lord.
3010.
And we will file our written notes on that day itself.
We have already
Let
filed.
us first hear your oral
Yes,
submission,
absolutely,
then
absolutely.
you'll file your written notes. So why are you preempting us from hearing you?
Well,
Lordship, I have already filed that is on
All
record.
Yes.
I am obliged, my lord.
Typing item 67.
May please, Lordship. My lord, petitioner participated in the selection process of Central Armed Police Forces, my lord, for the year 2018, my lord. 2018, my lord. So he got the cutoff mark, but he was not given the appointment on the ground that he got the, my lord, avail the relaxation of height, my lord. For that, he was not considered under general category. The petitioner approached this honorable court, and this honorable court direct, my lord, kindly see with petition, page 57. This honorable court direct the.
You were declared unfit in
Now,
medical
my lord.
examination.
Yes. Now, my lord, this honorable court direct the respondent to appoint the petitioner. Accordingly, the petitioner was appointed, my lord. Kindly see the appointment order, my lord. Page 64.
After appointment, there was a medical examination.
Yes, my lord.
Why?
Because my lord, petitioner original medical examination was carried out sometime earlier, my lord. Initially, petitioner was not given appointment.
Petitioner was not given?
Appointment order, my lord.
Ah.
So he approached this honorable court. This honorable court direct the authorities to appoint the petitioner.
Ah.
So there was some delay in appointment, my lord. Therefore, they again medically check up after joining, my lord. But initially, he was declared fit, my lord, by the medical board. Now kindly see page 64. This is the appointment order, my lord.
So after getting the order of the court, you must have been very happy. So you treated yourself with all the goodies and became overweight.
Yes, my lord.
You are found to be not fit.
And kindly see, my lord, page 64, page 65, my lord. Page 65.
Which order are you referring to? Earlier order?
Earlier, my
Page
lord.
75.
Yes, my lord. No, my lord. Page, my lord, 57, my lord.
57.
57. An operative portion, kindly see, page 63. Page 63. In view of the reasons stated above, the respondents are directed to accommodate the petitioners and appoint them in vacant post of Constable GD in Central Armed Police Forces within a period of 3 months from the date of receipt of certificate of this order. What happened, my lord? Petitioner, my lord, got the relaxation of height, my lord, in respect of Assam, my lord. So he was not considered as your category initially, my lord. But this honorable court held that since the height relaxation is granted for all the candidates for Assam, my lord, so petitioner will get the, my lord, selection in your category, my lord.
Yes, madam, after appointment, why did you send him medical?
Because his medical was done too earlier. After during that period, he may be.
These things you should have pointed out before the court, when the court disposed of the writ petition with a direction that he should be appointed.
Yes, that specific instruction.
And there is a specific direction by the court that you are to accommodate the petitioner and appoint him in the vacant post.
Yes.
So what you cannot do directly, you are now seeking to do it indirectly. Under what provision of your rules do you have the medical examination to direct him to appear before the medical authorities? On whose recommendation? Who has sent him? Is it your commandant?
Yes, Mr.
Yes, yes. That specific instruction.
Page
Then
69,
we will
I have
call
to
your
take
commandant here. This is an out and out violation of the direction of the court. We should proceed in contempt.
Further, my lord.
Kindly allow some time, lordship. I will bring that instruction as per which provision that.
There is a specific direction
Yes,
that he
lord.
should be appointed. If you think that he was overweight, unfit, you should have got a review of this direction that in view of this, we cannot appoint him. You sit over this order, no review, no appeal, and then you resort to a procedure that he is unfit. Which means this order has not been implemented effectively.
He was appointed and after that.
That's what we are saying.
Yes, lordship.
If the idea is to merely show that we have carried out the court's order, but will not allow him to work, that is overreaching the directions of the court. Unless you satisfy that no, the rules prescribe that after 3 months, 6 months, he has to periodically present himself for medical examination. Was third counsel for the parties. The petitioner before this court is aggrieved. by the which order?
Important page 71, my lord.
By the order dated by the order dated 25 July 2023, whereby the petitioner, upon being detailed before the review medical board at the before the composite hospital, BSF. Stop. The petitioner, the counsel for the petitioner submits that earlier the petitioner approached his court by filing WPC number 3764 of 2021. This writ petition came to be disposed of along with another connected writ petition. Stop. The
Petitioner
upon
is
hearing the counsel
3809.
for the parties.
3809 is the petitioner's petition.
Huh?
3809 is the petitioner's petition.
Sorry?
WBC number 3809 is the petitioner's petition.
3809. Okay. 3809 of
21.
21, which came to be disposed of by order dated 11/8/2022. Upon hearing the counsel, this court specifically directed the respondents to accommodate the petitioners and appoint them in vacant posts of constable, GD, in any central armed police force within a period of 3 months. From the date of receipt of a certified copy of this order. Stop. The grievance before the writ petition, before the writ court, before the coordinate bench was that though the petitioners belong to the reserve category, they had secured more marks than some of the selected general category candidates in the selection process. However, these appointment orders were not issued to the petitioners on the ground that they had availed of the chest and height relaxation prescribed for all candidates for the state of Assam. Stop. The respondents rejected the candidature of the writ petitioner on the ground that they could have been considered only for the reserved category posts and not for general category posts. So, under such circumstances, the writ petitions were allowed with the direction to accommodate and appoint the writ petitioners in the vacant posts. Stop. Para. Pursuant thereto, the writ petitioner came to be appointed in the BSF. Stop. Thereafter, by the impugned, thereafter the petitioner was detailed for medical examination and was directed to appear before the review medical board. Stop. The medical board gave an opinion that the petitioner was overweight and therefore found unfit. Stop. Being agreed, the present writ petition is filed. You have filed your counter?
Yes, ma'am.
Yes, we have filed.
The respondents have filed their counter affidavit. Stop. It is seen that the direction that the order dated so and so passed in WPC so and so was not, attained finality as no appeal or review was filed by the respondent authorities. So, perusal of the order passed by the coordinate bench reveals that there is a specific direction by the coordinate bench to the respondents to appoint the petitioner in any central armed force within a period of 3 months. Stop. And the same was accordingly undertaken by the respondent authorities by issuing appropriate appointment orders. Stop. Although the counter affidavit has been filed, that CGC representing the respondents, on a pointed query made by the court would not refer to the specific provisions which require a person to undergo medical tests and consequently are liable to be discharged or dismissed from service if found unfit. When was he appointed?
2023, my lord.
Provisional appointment is offered, Lordship. Provisionally selected.
7 February 2023, my lord. 7th of February 2023.
Petitioner was appointed provisionally on 7th of February 2023 and he was found unfit on 25/7/2023. Better. Although the respondents were represented before the coordinate bench at the time when the order dated 11/8/2022 was passed, disposing of, allowing the writ petition filed by the writ petitioner in the earlier round of litigation, it is seen that the writ petition ultimately came to be allowed with a specific direction to appoint the writ petitioner and 2 others in the vacant post of Constable GD in any armed forces, Central Armed Police Force. Stop. Unless the respondents are able to explain by reference to appropriate rules or notifications, it will appear that the respondents notwithstanding the specific directions passed in WPC number so and so by order dated so and so, have proceeded not to effectively implement the order as directed. So under such circumstances, at the request made by the respondent counsel to complete her instructions with regard to the queries raised by the court, matter stands deferred to be listed after 2 weeks.
Matter was made part hard, my lord.
Not parted. What parted?
Date may be fixed, otherwise.
It will come after 2 weeks.
2023.
21st November, 17 November, sorry.
My lord, published.
Published.
For hearing item 57.
Remember, this is that removal from service, very thin penalty. I am relying on a coordinate bench judgment.
We.
And your lordship on the last
requested
occasion
you to.
instructed to produce the relevant
No, no,
record
we
of Achyut
requested,
Kolita.
we requested you to, for subsequent judgments passed by the apex court on this aspect. There are judgments.
My lord, one earlier judgment is there. One earlier judgment is there on the same analogy.
All right. We have heard you essentially.
And my lord, exactly in the coordinated by judgment, that all the charged officials, altogether 8 charged officials, 2 or 3, same, my lord, except the difference, in the judgment of the coordinate bench, if your lordship, the entire charge was quoted. Page 151, your lordship, entire charge was quoted. And the findings of the inquiry officer also quoted, my lord. Same was the charge, same was the finding. Same except the difference in money in all the cases. And here table was also there, my lord, because none were removed from service, same except this petition. And joint representation also given by these petitioners. And now, my lord, I have also brought a similar judgment. It is, of course, it is the earlier judgment, my lord. Last page, my lord. It is a Supreme Court judgment reported.
You given this copy.
My lord?
This is Anand Regional.
Yes, yes.
Yes, that copy is already here.
Here, my lord,
What are the respondents are supposed to produce the records?
Yes, on the last occasion, your lordship.
Yes, I have records.
Instructed.
You have.
Yes, my lord.
Achyut Kolita, only your lordship wanted to have to look into the record of Achyut Kolita. The against the compulsory retirement was given. Penalty was substituted by modifying the same with compulsory retirement. There also it was observed, my lord. Only 2 paragraphs of the judgment of the coordinate bench.
My lord, here the comparative statement, my lord, against the each accused persons, my lord. Lord, you just kindly see the chart, my lord. Details of the departmental action against the officers, so and so. First, Achyut Kolita, DP number so and so, and neighbor enquiry officer Ganesh Rajbhoghi.
These are not the records.
No, the record is there, my lord. I have the
You
record.
show us from the record.
No, I am only going to see last occasion, see, my lord, everybody is, my lord, in different, my lord, punishment, not the same punishment. And in appeal, it may be, it is some, to some extent, some modified and not modified. But in the petitioner's case, not modified. In appeal.
Only petitioner, except 8, my lord.
Maybe, my lord,
Only
because
petitioner.
the involvement of the petitioner is, my lord, serious.
My lord,
That's why, my lord, he said every case has his own case, my lord, own facts and own, my lord, merit.
Lordship, this was a specific observation is
We
made.
wanted to see the
Record.
materials for Achyut Kolita.
Yes. Yes, your lordship.
What you are showing us in the chart are the original orders passed by the departmental authorities, which subsequently came to be modified by the appellate authorities.
Appellate authority.
Where is that updated chart?
That is the, my lord, Achyut Kolita, the first person, my lord. As per this honorable court's order, my lord. As per the honorable court order, it is to be modified.
Whatever it is, some orders are passed by the appellate authority also.
Appellate authority, my lord, passed order, my
But
lord.
why are you giving us
Yes,
a
yes, sir,
chart
yes,
which is only on the basis of the departmental authorities?
There is a order, my lord, in the chart below, my lord, order is there, my lord. The DP order, all are DP order.
Lordship wanted to see the record. Okay.
This is not the record. These
This
are
is not the record.
This is not the record. You mark out the this thing and give us the record, we'll examine it. Relevant portions. What was the order in respect of Ochut Kolita?
Ochut Kolita, my lord, his statement is there also. my
He was
lord.
removed, first removed, my lord.
No, what order was passed by the court?
By this court, my lord, that is in my rejoinder,
Modified.
rejoinder affidavit, page 16, annexure C.
What was the decision?
Yes, lordship will find. No, the court finding and relevant operative party para 11, page 39, running page 174. Only difference is the amount of money. That was the observation. All the charge official. Same charge, my lord. Page, lordship got it, page 174.
Alright.
Started from page 16 of my,
We will pass orders
151.
on Tuesday. For delivery of orders on Tuesday. Third council for parties. Records call for have also been received by the learned government council.
I will need to flag mark it, my lord. I will need to flag mark it, my lord.
Flag.
At such tomorrow, my lord.
Tuesday,
Tuesday, my lord.
my lord. My lord,
list on Tuesday.
any other date, my lord, 28, 27, I am leaving for Delhi. And 28, I will come back. After 2, any date, my lord. After 2 or 3, any date.
4th,
Oblige to,
4th November.
oblige to, deeply.
Oblige.
But I have appeared for 58 and 59.
What are these matters?
These matters, my lord, they are all, in all the matters, my lord, the different categories. The 15 and 59 are the helpers, and others are the junior assistants and CPS in.
What are you challenging?
Challenging the order of termination.
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 Departmental proceedings.
No
Well,
proceeding.
departmental proceedings, these petitioners, well, in all the matters, they were working in the establishment of NRC Miller. And the grievance in all the petitions perhaps is their termination during the continuance of the NRC process, my lord.
Page number 130.
Different designations, my lord. Item 60, they are junior assistant.
What are the grounds for challenge?
Further supervisors for the other.
What are the grounds for challenge?
Grounds, my lord, the first main ground is, my lord, the principle of natural justice is not followed, my lord. There is no, my lord, from the termination order, your lordship may peruse page number 136, my lord. One of the termination order, my lord. This is one of the order, my lord.
There is a specific act by which our regulation by which our services were governed. And that contemplates a procedure for termination. That was not followed, firstly. Secondly, the law itself says that the NRC process should continue as per the NRC city.
Your termination has not foreclosed the NRC process. It is continuing.
So, Lordship, no new incumbent is taken, but we are out, some of us are out.
Where are the rules? What rules?
There is a regulation.
Where is that?
It's the Citizenship Register of Citizens, issue of Central Identity Cards Rule 2003.
My lord, page number 60 of the item number 58, my lord. Page number 60. The relevant.
Lordship, at place 60,
Relevant.
the relevant.
Which clause?
Clause 8. Lordship.
What about clause 7?
Lordship, that is, that thing, there is no allegation of any misconduct or just, Lordship, we are out by a blanket order, Lordship. Lordship, in these matters, I've been led by senior counsel, Mr. P.K. Goswami, Lordship, would appear.
Counsel for the parties submit that they are led by Mr. P.K. Goswami, senior counsel. As the
Item 6 now led by K.N. Chaudhary, alternate.
and Mr. K.N. Chaudhary, senior counsels. Submitted that matters be taken up on some other dates. List accordingly. After 1 week.
After 3 weeks, Lordship.
1 week.
One.
Mr. J. Payne is for
NRC.
NRC. Mr. A.K. Dotto for Home. And Mr. Sharma?
Same Lordship. Lordship, can it be after 2 weeks, Lordship?
All right, after 2 weeks. Yes.
Lordships, with your kind permission, since the preliminary objection has been taken by me with regard to the maintainability of the writ petition, if your lordship permits, I can start my arguments. Otherwise, my learned friend can start it. I mean, subject to your directions.
Counsel for the respondent wanted to seek another date, but in your absence,
But now that he's there, I can finish it off. I think we are another 20 minutes here.
you can finish it off, but whether we'll be able to finish it off for today.
That's a big question mark.
So I don't want to keep it part heard.
Not at all.
So you are only raising the preliminary issue.
Yes, my short notes are there. So a counter affidavit is there where I have
You are not
taken,
questioning the merits of the case. are you?
not at all now. Because the very fact that it is not maintainable before this forum, the question of my challenging the merits of the case doesn't arise at all because he has another forum. It's a contract of service, a private service. Nothing to do with state instrumentality.
He's employed under what? SOS?
SOS is an NGO which is totally run by the funds raised from the, sponsorship and donations. And there is no involvement of the government in any manner whatsoever, excepting the guidelines which we have to follow because it's a child's organization and we have the Child Welfare Department and the Women and Child Welfare Department. That is the only thing which is the guidelines which we are following. According to him, he says it's Article 14, Article 21, things like that. But then he has a forum. A labor court is there for him to address his discharge from services. It's a contract of service which he had voluntarily signed, accepted, and continued. Actions were taken, promotions were given, everything was done as per that particular rules and regulations. Today, to question it in the forum of writ, that's my only concern. He has a legal remedy, but that legal remedy is not before this forum.
So this is a government aided organization, my lord. And my lord, that is very well come under the Juvenile Justice Act, my lord. And there I'll satisfy this honorable court, my lord, but I think today, my lord, it will not be possible to complete the entire hearing, my lord. Because for the maintainability issue also, the honorable court will see with regard to how the organization is functioning.
What are you challenging here?
Termination, my lord. My only point is, my lord, I have been terminated from service without, my lord, any notice, without, my lord, because the organization has its own rules, my lord, which says that either 1 month's prior notice or in lieu thereof, there has to be, my lord, my service benefits has to be given, my lord. But the termination word itself, my lord, is discriminatory, my lord, because with that letter, my lord, I'm not in fact getting any service in other organization. You know. I was a student of Delhi University. Then, my lord, on campus placement, I was placed in this organization. I gave my 7 years of my time in this organization. And then upon completion of my period, my lord, they have terminated me from service.
Where is
my lord.
that order of termination?
That, my lordship, will find page 55. Termination letter.
Is there an interim order?
Not at all.
No, my lordship. Interim order आपने होगा?
नहीं है नहीं.
हाँ, नहीं है ना? I ought to have been discharged, my lord, not terminated, if at all. But that is also, my lord, without following due procedure, they have terminated me. My lord. I have not, my lord, committed any misconduct also. So, my lord, date may, as per the convenience of my learned friend, my lord, the date may be given, my lord. I will satisfy this honorable court whether it comes under the purview of Article 226 of the Constitution of India or not, my lord.
We can give you half an hour if you can complete.
I can.
Both of you.
Because, my lord, my learned friend has filed a reply, detailed reply, relying on Supreme Court judgments and all, my lord, and other High Court rulings, my lord. I have filed my rejoinder, based on which I placed, my lord, RTI replies of different organizations, different government, my lord, units, my lord. So it will take some time, my lord, because half an hour, my lord, it has to be part heard, my lord, otherwise.
Yes.
May I?
Yes. No, you can, we'll take it up on some other date since he has expressed.
As you
we can-
please, your lordships, as you please.
Whatever date suits you, you can take it.
December, your lordships. Anytime, December 8th, 9th, 10th, whichever, because my surgery will be entirely for the November. I'll be not allowed to travel. That's the main problem. So your lordships can give any time after the 8th, 9th, 10th, 11th, whatever lordship's diary suits. If it
8,
can,
9, 10, 11 will be virtually in the last week of December.
no, sir, first,
No,
Ah.
we are closing from
end of December.
19th is the effectively the last date of this year. 19th.
Yes, your lordships.
So
last week will be
8, 9,
Muslim.
10, we don't know. We can we can have it in the first week of December if that's or
The lordships can then second, third, if it's convenient.
yeah, 2nd of December.
Can it be higher up, first 5? I
You
don't know.
make a mention.
Huh?
You make a mention.
Gratefully.
Or you ask your assisting counsel to make a mention at 10:30 in the morning.
No, I'll be here. In any case, I come a day before, so I'll be here on that.
All right. So you can make a
do it
mention.
online also if you want to, otherwise.
But then this gentleman has to coordinate and,
Yes.
because you will be here in person and I'll be on that. I mean, I somehow feel that a little.
You can make a mention. We'll fix it on 2nd.
Right, your lordships.
Third council for parties, considering the issues involved in, including the question of maintainability. The the matter will require some hearing. Due to paucity of time today, the matter stands deferred to be as agreed to by the council for the parties, be listed again on 2nd of December.
Can it be on third, Miller?
No,
Third, Feb?
I'm here. You
2nd
tell
of
me.
December.
Second, third, any-
May I prefer third, my,
Third is a miscellaneous day.
then my lord, can it be on?
No,
Fourth, my
second. Let it be on 2nd. What is your difficulty? You make your adjustments. We have given you sufficient time, more than a month.
Yes, my lord.
Make your adjustments accordingly.
My lord.
You arrange your calendar as per the calendar of the court.
I have some decision matters, maybe my lord on.
You have to
Anyways,
take
my lord,
it.
I leave it there.
Yes. Second.
extremely grateful, Your Honor.
Deeply obliged.
Mighty good. School will.
I think 70 and 71.
Your Honor, can you take up 71 first? 71.
71. Item 71. Yes.
Yes, my lord. In this case, my lord, I have challenged the de novo inquiry. Which I have annexed as Annexure B, page 21.
Where is the inquiry report?
My lord, they have not served the inquiry report to me. My lord. They have not served the inquiry report. But
You
your
will
lordship,
have to call for the records.
record is already available, my lord.
Record. Where is the inquiry report?
Record for this question a year ago. What is it? For this question.
They have submitted it, held their affidavit.
Affidavit file, Lordship. But the record, Lordship, so far in my office, not the record.
Do you have the records with you or not?
No, Lordship. No.
Call for the records.
Yes, Lordship.
Heard counsel for parties, this writ petition is filed by the petitioners. You have filed both the writ petitions.
Yes, ma'am.
Why?
Another one is regarding suspension.
Earlier was
Suspended. You are now what? Discharged.
Removal.
Now, my lord, I have not been discharged. De novo inquiry has been given. That has been stated by your lordship.
The WPC 4819/24 is filed with the petitioner putting a challenge to the order dated 6th of September 2024, whereby the respondent authorities initiated a de novo inquiry against the petitioner. Stop. The learned counsel for the petitioner submits that in terms of the judgments rendered by this court, de novo inquiry is not permitted except to make corrections if required. Stop. The further submission is that the inquiry which was earlier conducted, the copy of the inquiry report was never submitted, served on the writ petitioner. Stop. Where the respondents have contested the matter by. You have filed affidavit. You
Yes,
filed
Lordship.
an affidavit.
Affidavit filed.
However, the inquiry report is not enclosed to the writ petition, the affidavit. Stop. Therefore, it will be necessary for deciding the issue raised, to call for the relevant records. Stop. Let the records of the case be called for, which must include the disciplinary proceedings initiated earlier, including the inquiry report by the submitted by the earlier inquiry officer. So, WPC 1590 is also filed with the petitioner challenging the suspension.
Yes,
You're still under suspension.
still under suspension.
Please put these matters again after
2 weeks, Lordship.
2 weeks.
Wait, maybe 15.
November.
Obliging.
72.
Make pictures.
Yes.
But here the petitioner is challenging the dismissal order, my lord, dated 30th of June 2023. But here the inquiry, departmental inquiry has been dispensed with by exercising power under Article 311, sub Article 2 proviso, my lord. Your Lordship, kindly have look at page 29 for a moment, Lord. Yes, ma'am. This is an order of suspension issued on 29th of June 23, ma'am. Pending departmental inquiry, Inspector UB Biman Chandra Roy of Nalbari D is placed under suspension with immediate effect of his serious misconduct. During the period of suspension, his headquarter will be Nalbari and will draw the subsistence allowance. In just 1 day, my lord, without any so-called notice, without anything, my lord, the order has been passed at page 34, my lord. Page 31 is the type copy of that order, my lord. It is dated 30th of June 2023.
What is the name of the petitioner?
Biman Chandra Roy.
Huh?
Biman Chandra Roy.
Where is the order of dismissal?
My lord, your lordship finds at page 34.
34.
4. But para 1 of that order reflects the allegations, floods, in respect of which an FIR was also lost.
Counter affidavit or anything filed?
Yes, counter. Your lordship has been pleased to call for the record, my lord.
Oh, I have received the record also, ma'am.
What does it say?
Record says, my lord, this is a crime is a heinous crime. Is the OC of the police station. He himself involved in the my lord type of
No, we are not on that. We are on the
record says, my
dispensation
lord,
of inquiry.
order have been passed under article my lord 311 2B. So he was absconding. That's why they could not my lord inquire the
Does it say?
matter. That's why they.
Where is
taking-
that? Where is that? Let us see in the record. What does it say?
Otherwise, no DP is my lord there. No record, my lord. Inquiry is made by the DAG.
Where is the report of the CCTV footage?
That is not with us, my lord.
You have to get it.
That was my lord CCTV footage. They waiting for it, my lord. They were not collected.
Why has it not been collected?
But their statement is there, my lord, one woman police constable, she, my lord, when entered in the room, my lord, she saw she was pulling the pant, the victim.
That is, and then you see how it is qualified. She has assumed that the incident had occurred. She is
Okay.
not an eyewitness.
No, my lord, at that
So
moment.
if you have CCTV footage submitted, the report is still awaited. Where is the
Awaited.
CCTV footage? That will
Important, my lord.
That will decide everything.
My lord, I will have to collect it, my lord.
Due respect, my lord. The test here is, my lord, whether it was reasonably not practical for them to conduct the department proceeding. My lord, I am also facing a criminal trial, my lord. And the ground, my lord, your lordship has seen in the order itself, the respondent authority has recorded.
They have given reasons why it is not reasonably practicable.
Yes, my lord, that would be subject to judicial review.
That's correct. But
On the
question
parameters
is-
laid down by the apex court.
So which judgment are you relying on?
My lord. 2015 8 SCC 86, my lord.
The
86.
Yes.
Well, this was a case, my lord, where the appellant case was dismissed because it was found out, my lord, there were no witnesses who were willing to adduce evidence. Now the apex court has set out the parameters, my lord.
Paragraph?
Paragraph 17, 18, my lord. 19, 20, my lord. The lawsuit permit, may I read para 17?
Yes.
Before delving into the pointed issues canvassed at the hands of the learned counsel representing the appellant petitioner, it is necessary for us to notice the parameters laid down by this court for invoking clause B of second proviso to Article 311(2) of the Constitution of India. Insofar as instant aspect of the matter is concerned, the norms stipulated by this court for the above purpose require the satisfaction of 3 ingredients.
Where is the judgment, Tulsiram?
Well, that has been quoted, my lord, para 18. Firstly, that the conduct of the delinquent employee should be such as would justify one of the 3 punishments, namely dismissal, removal, or reduction in rank. Secondly, the satisfaction of the competent authority that it is not reasonably practicable to hold an inquiry as contemplated under Article 311(2) of the Constitution. And thirdly, the competent authority must record the reasons of the above satisfaction in writing. On the issue whether it is reasonably practicable to hold an inquiry as contemplated under Articles 311(2) of the Constitution in India is concerned, this court elaborately expressed the required norms in Union of India versus Tulsiram Patel. It is quoted here in blood. The condition precedent for the application of clause B is the satisfaction of the disciplinary authority that it is not reasonably practicable to hold the inquiry contemplated by clause 2 of Article 311. What is pertinent to note is that the words used are not reasonably practicable and not impracticable. According to Oxford English Dictionary, practicable means capable of being put into practice, carried out in action, effected, accomplished, or done, feasible. Webster III in New International Dictionary defines the word practicable inter alia as meaning possible to practice or perform, capable of being put into practice, done or accomplished, feasible. Further, the words used are not practicable, but not reasonably practicable. Webster III New International Dictionary defines the word reasonably as in a reasonable manner to a fairly sufficient extent. Thus, whether it was practicable to hold the inquiry or not must be judged in the context of whether it was reasonably practicable to do so.
Let us call for the CCTV reports.
But my responsible submission would be, Lord, CCTV report will not cleanse the issue.
We don't know.
Lord,
how do you know?
No, because the parameters have been done. What the authority says that he has been absconding. Lord, in one day, if he comes to a conclusion, Lord, he's been absconding, that itself is unreasonable. And your lordship would see.
See, he is the OC of the police station.
My lord.
Right?
My lord.
So all or any of the police constables or officers,
my lord,
are subordinate officers.
My lord.
Right? So it's possible that in a given case they may be unwilling to depose against him.
Lord, that is not the reason. Lord, where is the charge sheet? Lord, suppose there has to be an allegation of charge sheet.
Therefore, we
My lord,
thought
therefore, my lord, on
we
29th,
will examine the
Lord,
CCTV.
definitely, my lord,
reports
your lordship
also.
may examine, but my contention before lordship's consideration is this. On 29th, my lord, when they suspended me for withdrawal of departmental proceeding, 30th, they dismissed me, my lord.
So you tell us from these
My lord.
judgments.
My lord.
What is that specific parameter?
Parameter is this, my lord, they must, my lord, there could be one possibility that if it's a criminal offense,
There is no specific parameter.
parameter is there. Parameter is,
are
my lord, that
it leads, it's a threat to security, number one.
no, my lord,
Number
with due
two-
respect, my lord, that is not the,
Number two, that it's not reasonably practicable to hold it. That's the only ground.
and the reasons has to be recorded. And the reason is he is absconding.
No, the reasons are recorded, whether these reasons are correct, incorrect.
Therefore, my lord, my submission for your lordship's consider is what is the reason reflected in the order, my lord? Your lordship has to see that, my lord, whether on the basis of that a case has been made out or not. Therefore, I say that CCTV report, yes or no, will not make any difference. my
We'll
lord.
see that. Let us first have a
My lord,
look.
yes.
Let us first have a look, because there is an onerous responsibility on this personnel as a police officer.
I understand, my
The
lord.
incident is inside his police station, where he has absolute jurisdiction.
But
The
still,
midnight.
my lord, they say it's impracticable. Not for that reasons, my lord.
It's a midnight also.
Lord, in the fact that in one of the judgment has been referred, the fact that they have conducted a preliminary inquiry, they ought to have conducted a departmental proceeding, Lord. My Lord has seen the basis of his suspension or whatever it is based on a preliminary inquiry. If they can conduct the preliminary inquiry, they can very well conduct the further inquiry also, my Lord.
Therefore, you are not accepting the allegation, are you?
No, no.
Therefore, we wanted to see the CCTV to find out prima facie if there's anything, at least the reports. The CCTV will require a report coming from the authority concerned.
My Lord, in fact, the petitioner is also facing a trial against a POSCO case.
Trial will
It's
take its
different
own
thing.
course. Trial will take its own course. There is no dispute that trial and departmental proceedings are on two different forums.
Clap together.
Lord, had the charge sheet been issued to me, Lord, we could have taken one defense, Lord, if the department proceeding is based on the same facts on which the criminal case has been
We can
instituted.
foresee that. Therefore, we are asking for the reports, CCTV reports. This is in a very narrow campus, but
Yes, yes, it's a narrow campus, my Lord.
Mr. Sutia, your
Yes.
report reflects that some CCTV reports are awaited.
Yes.
What has happened to that?
That is to, my lord, I will have to collect it, my lord, that is not there. But they have said, they had also threatened me saying that there were CCTV camera. That's
Heard
a
counsel for
that's
parties.
serious
The
thing, my lord, and my
pursuant
lord.
to the earlier orders, the relevant departmental records pertaining to the orders passed against the petitioner by the competent authority discharging him from service, dismissing him. Is it
Yes,
dismissal?
yes.
Dismissing him from service without, under section 311(2), under article 311(2), C, read
B,
with,
my Lord.
huh?
B.
B,
2B.
Proviso
B.
2B.
Read with the provisions of the Assam Discipline and Appeal Rules 1964. Reflects that CCTV reports of the concerned police station in which the petitioner was the officer in charge in respect to the alleged incident have been called for and the reports are awaited. So, Mr. Sutia, learned additional senior government advocate, submits that he would like to complete his instructions in this regard. He prays for a week's time. List again after a week.
Can it remain as part heard, my Lord?
Sixth of November, 6th November.
6th November.
Part heard, my Lord.
Since the matter has been heard at some length, the matters will be treated as parted.
Obliged.